But I say for only state 2 p.m. We have 5 yesterday. There is urgency because huh?
It doesn't matter. I can't say 2 p.m. Maybe it is time permits. No 2 p.m. There's a list, that Mr. Carlton, there's a list of cases. They're all waiting their turn.
But state holiday is
So what? But there are other lists in front of you. You cannot jump the queue.
right.
Huh?
But finishing those.
That's what I'm saying. That's what I'm saying.
So let it come. We are giving the
What is the matter about?
at the minute there is a water for supply customized ambulance.
Huh?
Water for providing customized ambulance.
Huh?
This ambulance by this 2024. So there will be a delay of 10 days because the manufacturers, my lord, they took some time. So I can, the petitioner, their MSME unit, they are going to deliver by 30th of this month. So in the meantime,
Already the contract has been awarded to somebody.
yes, no. Contract has not been awarded.
Then they're going to deliver.
It has not been awarded. They have given a letter that it seems we have failed. But in the meantime, they asked me to deliver a whole ambulance, which we are doing it. Only that apprehension part, suddenly if they do it, cancel it, my lord, this MSME unit who has taken loan from the bank, they will suffer irreparable loss. So 10 days, my lord, that window is required. Within 10 days, the ambulance is reaching Guwahati on 25th, and after the registration and all.
I don't know. We'll see. We'll see.
Yes.
My pleasure. My lord, this matter I have filed yesterday, my lord. It may come on Wednesday for motion.
We are so packed. 27 we are packed.
27, my the urgency is there.
What is the urgency? What is
The
the
police atrocities is there. On 27, my 27.
Huh? First.
But, yeah.
What is that? He's in jail.
No, that's why only he may be, because police are calling him like that. Anything may happen, man, on 27.
Is that a bench for matter?
Benchport. Police atrocities in Benchport.
No. Probably I don't think it's it. We have never had any case like this, police case. No.
And
I think
FIR,
it's a-
non-registration of the FIR is also Benchport.
No.
Police and army atrocities. What for them?
Yes.
In regard to item
Sorry.
31,
Yes.
my lord, can it be taken up on 1st of September?
31. Okay. Right.
My lord, can you make listed on 2nd September? All right.
Okay. But second also we've got
Then my lord, pass it.
we are 16 or second now.
First, third.
On the prayer, the party needs a matter on third.
Much.
Your Lordship, I beg to mention item, I beg to mention for listing of WPC 5889 of the 2022 and WPC 5844 2022. It's a link matter, your
It's a
link matter.
linked matter with what?
What a link matter, Lordship?
They are not listed today.
No, yeah, for
Okay. Sometime.
that legal Lordship, it's for 27. There's an urgency.
No. What agency? What's the agency?
Matter pertains to non-payment of contractual fees.
No, Hari, madam. Your contractual bills were pertaining to which period? When did you finish your contract work? You've got no idea. What is the urgency? You don't even have an idea of when you finished your contract work. Please read the file, madam. Please read the file. Yes, next.
That legal Lordship,
After I just don't date, no date. No.
I beg to mention item number 26.
Huh?
Sir. I beg to mention item number 26. With the consent of the other side, kindly adjourn the matter for debate.
You're for whom?
This is a guidance.
Who's for the other side? Yes. What is the thing? No objection. Have you appointed an arbitrator on your part? Why?
We propose to one and a half.
No, Mr. Council, it's like this. Your claim is above 20 lakhs, correct? Above 20 lakhs, you need an arbitrate tribunal consisting of three arbitrators. In that case, you have got to appoint your arbitrator first and tell them to appoint their arbitrator. It's only then, when they say no, that it will come to the court. And the issue is that you have not waived that 12.5, I think. That is okay. You're right. On the prayer for adjournment made by Ms. A. Gaya, which is not objected to by the other side, is the matter after 2 weeks.
That's the I can.
40.
Yes, in
Yes.
this matter, I was required to file affidavit, but the deponent matter due to medical urgency, his accompanying his family at Hyderabad.
Okay, right.
Um,
Mr.
SK,
S.
SK. For response.
S.K. Roy. Have you spoken to the
Yes.
petitioner?
Yes.
Okay. Mr. S.K. Roy, learned counsel for the respondent submits that. He could not submit the affidavit as directed in view of the respondent having required to take his family outside Assam for medical treatment. This is the matter after 2 weeks.
They have taken listing of these two letters for motion on Wednesday, 27.
What is the matter about?
Urgency is for eviction. The petitioners, they've been running business in the allotted market space under the Vipuria Municipal Board, in the Lakshmipur district for the past almost 30 years. Now they have been issued eviction notice.
Railway line.
No, municipal board. Allotted space during the subsistence of the license period. Now they have been issued the eviction notice, and that will expire on 27. Just a few days back, that is the urgency. 27, this will probably they'll take over, they'll evict the
28, 27 are too many matters.
28. Okay.
May figure document for renewal petition 7253 of 2021 regarding cancellation of and next of kin
Next of kin.
and for matter.
Is a bench for matter. Cancellation of next of kin certificate is a bench for matter. I doubt. Huh? You go to the registry and find out. Okay, let them find. You go to the registry.
It is however, I think mentioned the matter for
I think it's a more of a bench three matter. I think. Bench four. I doubt.
properly lost the matter. Wait, then the lot can order preferred, but the lot back the matter.
Huh?
The lot 27 seems to be a pretty day. 28 the lot.
What is the matter?
Tender matter. The LOA has not been issued. In fact, it's the second matter in a litigation.
New case.
New.
Not listed.
Not listed. The lordship have filed it today. The filed it today. The PTM mentioned for 27. In fact, the lordship.
Have you filed it?
Yes.
What is the filing number?
3633 of 2020. Didn't file it.
28.
28. I'm grateful.
Lordship, I beg to mention, for listing up of two matters, Lordship, WPC number 6341 of 23 and 5193 of 2018, Lordship. The matters are relating to retirement dues, Lordship. Here, the petitioners are not able to get their retirement dues.
Retirement dues, a bench three matter, madam. That's a bench three matter, not a bench four matter.
Please, Your Honor. I beg to mention item number 17 of the meeting.
Yes.
My senior asked authority for.
Huh?
This is not well today. Hence, I pray for a short adjournment.
Right. Adjournment prayer has been made on behalf of Mr. R. Chakravarti, learned counsel for the petitioner, who is reportedly unwell. This is the matter of it.
Apply. May I pray your lordship, madam? Please, your lordship. In this matters, my lord, 1, 2, and 3, notice has been already issued. I think wrongly listed in the motion.
Even then, my lord, lordship, my prayer is very limited. We made a representation, my lord, making a prayer to take a decision. They are not going to take any decision.
To take a decision of what?
Regarding, my lord, settlement of Gohat.
Go hard.
go hard, because there was a decision taken by the government immediately after COVID to give settlement to all the heart, my lord, heart etc. Now, my lord, in rest of the, my lord, except Gwalpara, Dhubri district, my lord, all go hearts are already settled. Now they are not going to take any decision. We approached the authority, we made a presentation, days together, we pursued the matter. They are, my lord, keeping silent, and ultimately we had to come to court.
Is the Go hard, the heart is running anyway?
No, no. At present, it is, my lord, Captain Abbey.
You want to participate in the,
I want to participate, and I was the last lessee.
you're the last,
Lessee. I was the last settlement board.
but what is your right? What right of yours has been
Right, my
violated?
lord, in the sense, my lord, we have entire, my lord, villager farmers, they are suffering, my lord. Because, my lord, they used to, supposed to, my lord, sell and purchase the cow. For the
You
domestic
say the
purpose,
purchase of cow.
and for their domestic purpose, agriculture, farm, cultivation, marriage, etc. etc. Therefore, my lord, we are not saying that, we are not challenging even the action of the authority. We are saying you take a decision, either in your favor,
But
or
whether any right of yours has been violated?
because right to take part, my lord, as a, my lord, as a
No, Supreme Court has said,
settlement holder.
Supreme Court has said,
Right to take part or right to participate is obvious in a certain right. Substantial.
first you have got to show that your right has been violated, Mrs. Murthy.
By way of not taking any decision when all others, my lord, heart, my lord,
Okay, by them not taking a decision, what right of yours has been violated?
because I am going to be deprived of, my lord, of, or deprived of getting, my lord, opportunity to take part in the settlement process.
No. There is no fundamental right to take part in in a settlement process. There is no fundamental.
My lord, Lordship, kindly appreciate one thing. You are not going to take any decision. There was a decision taken by the government to settle all hearts.
Why does you do your own business on your own without government interference?
My lord, once it is my profession as a means of livelihood.
No,
I
the
certainly have
the
some right.
government is not interfering in your means of livelihood. They've got no right. You can't force the government to do
And
something they
administrative
don't want to
authority,
do.
my lord, statutory, they are the statutory authority.
Maybe the statutory authority, but you have got to show what right of yours has been violated by them not acting upon your representation.
My right is, my lord, very
No right,
substantive in the sense. My right is very substantive in the sense. We oppose the authority. We made an application for certain information under RTI. They issued, my lord,
Can you ask the government that you have to issue a contract
we are not saying, my lord,
tender
to give the
notice
consent.
for supply of sand or supply of wood or supply of stone? Can you do that?
No, my lord, we are
Or
not saying, my lord, give the
and for
settlement.
you it's a market that they have to settle the market.
We are not saying,
They don't want to settle the market.
yes, my
Simple
lord,
as
we
that.
are not saying give settlement. We are saying, my lord, you make an effort so that everyone may get an opportunity to take part.
If you're not listening, I think that's the end of the matter.
My lord, we want anything,
Military point was kept open on in the phone, very fast they might.
we are not,
There's no case, Mr. Counsel. No right violation.
Lordship, kindly appreciate one thing.
Just tell me one thing.
Madam.
Why you not taking a decision?
Well, entire whole district, it's the cattle market is not running.
Not running. So you take a decision, say that we're not running, that's all.
That can be done.
That's all. We're not saying that.
After the amendment implementation
Correct.
of
You see, this court is not asking you to run the cattle market. It is that you take a decision on the thing as per your discretion. And as per that, that's all.
Either in that.
He has to show some face to his clients also.
my law.
That he has
That
done
is
his
correct.
job. Otherwise, he's got no right.
After the enactment of the.
No
Cattle
legal
Act, my
right.
lord, the deputy commissioner.
No locus, Mr. Counsel.
My lord, Lordship, kindly, my lord, consider my prayer. I think Lordship knows, my lord, Lordship is well experienced. Right to be considered, itself is a substantive right.
No. This is not a. This is not a service jurisprudence, Mr. Counsel, where you have got a right to be considered for promotion. That is not the issue here. There's no right that the government has to issue an NIT and that it has to do something which it does not want to do. With regard to commerce, if it doesn't want to do, it won't do. You are left to your own devices.
Otherwise, I am going to deprive of taking part in, my lord, in the settlement process.
So you don't do that. It doesn't mean that Each and everything has to be done by the government and you have to participate in a government venture. They don't want to do it. How can you force them to do it?
No, we are not forcing. We are saying this is
Okay.
the art which have been settled for
Mr.
last 50
Council,
years.
please, no more, no more. I don't want to get into a, you know, make it an issue. It's not an issue. It's a
Fine,
dead
fine.
issue.
Fine.
Only thing is that I will record that you have got no right, but you take a decision.
Yes, yes. That's all.
Mr. Uh, S.D. Purkasta, Learned Council for the petition. A.K. Purkasta, Learned Council for the petition. Submits that. The respondents have not settled the Hatidura Go-Hut cattle market. For the last how many years?
On that, since 2022.
For the last 2 years.
2 years.
Thereby,
As per the decision.
thereby not giving an opportunity to the petitioner to participate in any tender process, tender/selection process that could have been initiated by the state respondent for settling the market with a successful tenderer. He submits that the petitioners have submitted a representation dated 17/7/2023
Connection 4.
to the block development officer / executive officer Hatidura block development block to invite a tender notice for settlement of the said Hatidura Go Hut for the year 2023-24. This period is gone. Your writ petition has become infructuous. Your writ petition has become infructuous.
No, my lord,
Yes.
June is
Yes.
the last. June.
Huh? Yes. They still it become infructuous. By the time it become infructuous, you withdraw this, you make another prayer for 24-25.
But June after expiring date is June.
No, please do not ask the court to make some kind of order on the basis of prayer for 23-24.
23 minutes for my lord, Panchayat year is going to be expired in June.
Correct. And June is just 3 months away.
Right.
April, May, June. That's all. End of March.
The law. No, my lord, they may consider and take a decision for the next settlement. My lord.
No. Okay,
Yeah,
okay. You take a decision for 23-24. That's what they pray. What have I said? For the year 23-24. Full stop. He submits that the Panchayat year for 23-24 would be for the period from 1st 1/7/2023 to 30/06/2024. Next time. Now he submits that as no decision has been taken by the said BDO brackets respondent number 4. A direction should be issued to the point number 4 to take a decision on the petitioner's representation. So submit para. Mr. S. Datta appearing for the PNRD department and Ms. U. Das appearing for point number 2. Submit that the petitioner has got no locus standi to file the present case. They further submit that the settlement period for which a tender notice is being asked for by the petitioner is going to end in 3 months. And as such, the writ petition has become infructuous. I have heard on considering the submissions made by the counsel for the parties. I find that no fundamental or legal right of the petitioner has been violated. Only because the state respondents have not issued any tender notice for settlement of the Hatidura Go Hut. As such, the petitioner cannot be said to be an aggrieved person. In view of no fundamental or legal right, enforceable legal right of the petitioner having been violated by the state respondent. This is as such, the writ petition does not appear to be maintainable. Keeping in view the judgment of the Supreme Court in the same Ayub Khan Pathan versus Union of India. So para 9 and 10. The above being said, the other issue raised by the counsel for the respondent also shows that the Panchayat year 23-24 is going to end on 30-6-2024. And as such, it appears that the appellants, that the petitioner's prayer made in the representation addressed to the respondent number 4 has in all probability become infructuous. However, there's nothing left with this TY. By the time they issue tender, this, that, even if they are allowed. In view of the reasons stated above, this court does not find any grounds to allow the writ petition to exercise its discretion in this case. Accordingly, the writ petition stands dismissed.
No, let us take it. We have already expressed the view.
I was just thinking, just 3 months.
No, no.
Just to satisfy your whims, no.
My lord.
Mr. Counsel, I can understand if the settlement period was going to start or going to end, still had a number of months. It's going to end. You want it for 23, 24.
Lord, for the future settlement, my lord, they can take it.
Then you can make a fresh representation.
Then Lordship, can you make an observation?
To the government,
No.
he can submit.
You can make a fresh representation.
He can approach government. Mail.
Then Lordship, can you make an observation? They will approach the government.
Observation is not required, my
No,
lord.
no, no.
This is
1, 2, and 3 same, my lord. Item 2. 1, 2, and 3.
both 1, 2, 3 said this time.
Apply.
Yes, well, okay.
But it will be different hearts. Huh?
Depend.
I told you in the beginning, you should withdraw and then make a fresh representation. Then we can decide. You're not doing it.
Then Lordship, can you then modify the order?
After I have no,
No, modify the order, then we'll approve the comment with the first.
there's no question of modification.
No, no,
I
couldn't-
gave you an opportunity.
no,
You didn't
couldn't
take the
follow, my
option
lord. I couldn't follow.
because you don't listen.
Right.
You only listen to yourself.
Oh, my lord, I'm sorry.
We are both listening to you only.
But I-
The problem is it takes two to tango.
I-
You're doing the
Fine.
tango dance all by yourself. That's the problem.
Then Lord, kindly modify the order and give us an opportunity to file representation. Simple one line order.
I'll allow you to withdraw the writ petition.
Yes, and make a representation.
No, I'll not withdraw the writ petition. That's all. With okay, if you want with liberty to file a petition.
Yes.
That I can do.
Yes. Alright.
Otherwise, this case will
Yes,
go.
all right.
But then you can make a representation for the
Yes.
next year.
For the next year.
Mr. Dutta, will allow since he has got to show something. Yes. So you put everything there till their statement, huh? Till their submission, huh?
Right.
Then from my submission, you just say, from my order, you just say, Mr. S.D. Prakashta at this stage. AK Prakashta at this stage. Submits that. He would like to withdraw the writ petition with liberty to file a petition. As-
We have liberty to file representation.
With liberty to file a fresh representation to the respondent number 4.
Fine,
Before the government.
Before the competent authority.
Yes.
Before the competent authority.
Fine.
The prayer the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, comma, with liberty as paper.
Okay.
Other two are same.
Same. Okay, this 4. Okay, right. Third, Mr. B. Chowdhury. Then counsel for the petitioner who submits that the order dated 22/3/23 passed in WPC number 3569 of 22 has not been complied with. Issue notice returnable in 4 weeks. Petitioner will take steps for service of notice upon the respondent by registered post with AD within 2 days. Within today. Within post of the day. This is the matter after 4 weeks. Acha, it is that.
My lord, my learned friend was supposed to obtain the instruction. Provided that. My lord, going by the instruction, it supports my case.
Very good.
But just now my learned friend is happy.
So everyone is happy then.
Yeah, then also I'm a bit technical, Lord. We have already cancelled it. And here the decision is yet to be taken. Here they are supposed to receive this amount also. But can they go to the order? Instruction.
As report, it has to be placed before the BDPOD.
Naturally,
Let it be go.
Lord will call it after my lord.
After Bihu
No,
or what? Right.
My lord,
Mr. P. Sharma, learned standing counsel for the AFDC has submitted letter dated 20/03/24 issued by the managing director AFDC, which is to the effect that the reassessment of revenue of the Chilochi bill has already been done as per the report of the additional deputy commissioner, Barbita. The same is to and the same is to be placed in the next BOD meeting for approval.
My lord, only problem is, my lord, because of the model code of conduct, perhaps during this period, there is not otherwise. But if the lordship says that it will be open to them, then because if there is a court order, then the model code of conduct will not come in this for implementing a court order. So it will be open to them, my lord, even before that also they can do.
How will it block? A model code of conduct should not disturb you.
No, normally they will not do anything because during this
Yeah.
period, normally, my lord, whether it is participant or imparticipant,
Chairman is a political person.
Huh?
Chairman is a political person.
that's why, my lord, because to implement court's order, there is no model code of conduct. If the lordship observes that it will be open to them, to
We
take a
have
call.
we have to place all the minor NPOs. Only for this we have to.
Let's wait. How does it matter? It's the question of money only.
So my lord, question is, my lord, we are out of position. But if your lordship passes an order, then
No,
then there will
no,
not be any problem.
because if he's a politician, then the problem.
And my lord, they support our case. That means, my lord, that their demand is also wrong. See, it was terminated because of non-payment of the demand. The demand is based on an assessment which has might be reviewed. Kindly see, my lord, they have given the workout also. For 767
When is
days.
the model code of conduct will be till
Up
April?
to June, my lord. June.
Where, I think we don't have.
My lord,
we will
my-
not- we will
I'm
not
not-
settle all of that during this.
No, no,
period.
no.
Will not settle anyone.
We'll not
No, no,
settle, we'll not
I'm
cancel,
not
we'll not
saying
do
that.
anything, Lord. No, no.
My-
No, no, anyway,
I'm not disputing that position. Only thing is, my lord, it will be open to them to take a call. Not to only clarify.
no,
this.
no, no, I think we'll leave it like that. Okay, accordingly, list this matter.
After, let it come after view vacation letter.
Yes, then accordingly, list this matter. After the bill cooking.
Dispose of lot.
Huh? Late possession,
Yes, but we have calculated if it can be
Huh?
disposed. Yes, we are going to pay lot.
you're going to pay.
Yes, but Vending director has a power of only 25,000.
How much? How much are you going to pay?
3,58,308.
Okay.
Another part is the damage for natural calamity.
Damage, so you go to, how can this court decide? Damage
That
part.
can be left open lot.
Damage part, so you do it. We'll reflect that. Yes.
Yeah, that can be left open lot.
And third, Mr. MK Singh, Learned Counsel for the petitioner, who submits that the mean mahal has been settled with the petitioner for 7 years, from 2022 to 2020, 2022-2023 to 2028-2029. Though possession of the fishery was to be handed over to the petitioner on 1/4/2022, the same was handed over only 8/12/2022. Full stop. The petitioner has thus raised that there should be adjustment of the money payable by the petitioner for the late possession of the mahal given to the petitioner by 251 days. Full stop. Settlement has been cancelled or what?
No. Notice of it.
Okay. We are not cancelling also, Lord.
Huh?
We are not cancelling.
I know. But where is you have not asked for damages. Where is that? Where have you paid for damages?
Repair and replace is there.
No. That is, we are not making, that is not your pay.
Page 19 is the notice. The lot of page.
Huh? What?
Page 16 is the notice. Sir.
So?
Asking 18 lakh lot. Sorry, lot. Page 22, notice for cancellation. Page 22, when access is.
Yes. So what about this?
Page 22, lot. Notice for cancellation. They have asked for 18 lakh. Lot.
So?
So without exempting that 251 days.
So now they're accepting this amount,
That can be exempted.
adjusted against this 18 lakh. So that's all.
That can be exempted.
That damages regarding that, that's a different issue. That's not here. That's not a part of the writ petition.
And this 18 lakhs may not be executed. After exempting this
3 lakh. They will adjust the amount. They will adjust this 3 lakh from this 18 lakh. So you'll have to pay maybe 14 lakhs or something, I don't know. Yes, right. The petitioner's counsel accordingly submits that the claim made by the AFDC to the petitioner for payment of rupees 18, 08, 099 in terms of the notice dated 20/02/2023 would have to be adjusted, keeping in view the adjustment of the money payable payable to the petitioner by the AFDC for giving late possession of the fishery for 251 days. This para. Mr. P. Sharma, Learned Counsel for the AFDC, has submitted a letter dated 21/3/2024 issued by the Managing Director, AFDC, which is to the effect that reassessment of revenue of Borjola, Nova Beach, Morrigaon district has been done and would be placed in the next BOD meeting for approval. As per the reassessment of the revenue done on Borjola, Nova Beach, it has been decided that
Two amount of.
rupees 3,58,383 would have to be adjusted. Correct? Against the dues payable by the petitioner. The next. Next, as the no, the letter dated 21/3/2024 is made a part of the record and marked as an extra. As the reassessment of revenue of Borjola Nova Beach requires the approval of the BOD. This court is of the view that but we adjust them, we wait or we close.
Close that matter.
No, it will be, we'll say that it should be approved. This court is of the view that as soon as the BOD gives its approval to the assessment of revenue done on Borjola Nova Beach, the amount, the rupees 18, no, the said reassessed amount payable to the petitioner amounting to rupees 3,
That is not three, the last part only. Plus 6,91.
okay, it's not 3 lakh.
Last part.
Oh, it's 6,91,617, huh? Instead of the 3, everywhere, huh? 6,91,617. The, what have I said? Assessed amount of rupees 6,91,617 in its meeting, the same should be adjusted against the dues payable by the petitioner in terms of the notice dated 20/02/2020. Where is 18,08,099 has been claimed from the petition. The petition is accordingly disposed.
That part of my payroll, that may be kept open.
But
Damages by natural calamity.
that is, yeah, that is not an issue in this petition.
My representation in prayer is also there.
What prayer? Prayer in the writ petition? What have you prayed?
To consider and dispose of that representation. File for natural calamity, damage by recovery. Otherwise, I will suffer. That's why I will, that dispose of that representation.
No, it is before disposal. The above being said, comma, the petitioner's representation dated
9 to 24, Lordship, page 19, Lordship.
page 19. The petitioner's representation dated uh, 9/2/2024, which has been submitted to the managing director AFDC, should be decided by the concerned authority within a reasonable time. And the decision should be communicated to the petitioner thereafter.
Correct.
Read petitions accordingly disposed.
Correct.
DB2, Police and Army Act. DB2, so why they coming here? Yes, but in item 9,
Equal Peter Millard in the NIT was
item 7.
equal NIT was issued.
Huh?
I submitted tender, but my tender was accepted, but no settlement was given Millard, but my installment has been.
Your financial bid was accepted. Your financial bid was accepted,
Accepted.
but no settlement given
No
to you.
settlement. Now, Millard, after 5 years, Millard, hand over, not hand over, Millard, to me,
The
Millard.
fishery was to be for how many years?
5 years.
NIT was issued when?
That is issued Millard in 2019.
NIT date?
Date was not given yet.
NIT in 2019.
There is a, kindly see Millard, page annexure 1 Millard, there is no date.
Okay, I'll believe you. Heaven will not fall if I disbelieve you. Okay. Anyway, so NIT of 2019. You submitted your bid in 2019. You were selected in 2019.
My lord,
Where they selected?
not given, nothing. On year Millard, they are selected.
The
I even Millard,
the bids were evaluated in 2019 according to you, and you were selected. No,
Said Millard, I am selected.
they said.
Yeah.
Who said?
The, it said authority Millard, respondent, issue Millard from the
How they told you by word of mouth.
mouth. Nothing
Wait.
given, only when now they have come Millard with a notice that you give me the area installment.
Where is that?
There Millard, kindly see last annexure Millard, annexure 7,
Page
page 25.
Page 25.
My lord. Made in annexure 7. It is issued by the additional deputy commissioner of the Kutubi.
So this period has ended. Yes, but
Period ended.
he says that any instructions?
No instruction, I have to take instruction. Otherwise, Lordship, NIT was issued in the year 2018. And if no, the settlement was issued, he could have approached the.
Correct.
I filed
But
it.
only he has.
Huh?
I filed the representation.
When did you file the presentation?
2022.
2022. And what were you doing before that, twiddling your thumbs?
Nothing, Millard. I also nothing, they also
Yes,
doing
sir.
nothing, they are not Millard even.
Now, did you, what about your earnest money? Any earnest money deposited?
Well, that is, that is, I am now telling you that should be
Most
given.
probably that should be, that was forfeited most probably.
I also instructed.
You were not worried. Your earnest money is with them. You submitted your bid. Yeah, we are content eating your dal bhat and just waiting.
Now only Millard, aerial instrument is speaking Millard, that is Millard my headache.
And anyway, I do not know why you submitted this. I know someone is not in the loop. Right now, I am not in the loop, but we'll see later on after your instruction. Either he's telling a lie or I don't know.
But in the notice, Lordship, at page 25, they are saying about some agreement.
That's what you bring that. I do not know. Maybe you'll have to go to the civil court. He doesn't know anything. He knows he has given money. He doesn't know the NIT date. He doesn't know when he was selected. He knows everything by word of mouth. Which particular officer told you that you were selected?
That is Millard, hopefully the deputy commissioner.
Deputy commissioner told you. Deputy commissioner, which district told you?
Millard, Huzai Millard.
Where have you stated that?
Millard, I have studied And there is a one Mr.
Where have you stated?
Settlement, paragraph 4, my lord. It was settled, no settlement was issued, my lord, no, it was not handed over to me. I deposited two installments. And also,
No, no, Mr. Counsel, you just said just now that you were informed verbally that you were selected. Where have you said that?
that portion, my lord.
That portion, what, selective amnesia?
On the installment, sir.
Huh? You've got amnesia now or what?
Only now, my lord, there, I was a file, my lord, 12/4/2023. SFC.
Right, third, Mr.
Here.
Abdul Rashid, learned counsel for the petitioner, who submits that the petitioner participated in an NIT NIT issued in the year 2019 for settlement of number 100 Doboka fishery for a period of 5 years. Full stop. Though the petitioner, as the petitioner was informed that he had been selected for settlement of the fishery, and due to which the petitioner had deposited 15% of his money for the period 1/12/2018 to 28/2/2019, 1/3/2019 to 31/5/2019. To the additional district commissioner, Hojai, by way of a treasury challan submitted in the State Bank of India. Baba. No order of settlement of the fishery had been issued to the petition. However, the petitioner thereafter submitted a petition dated 6/7/22 before the DC Hojai, praying for refund of the call deposit of rupees 5,000 and the two gift money installments amounting to rupees 3250. 3250 one installment or double two installment? Two amounting to rupees 3250. It submits that thereafter the petitioner submitted another representation dated 12/4/2023 to allow him to take possession of the fishery. While the petitioner was expecting an order settling the fishery with him, he was surprised on receiving notice dated 1/3/23 from the District Commissioner Hojai, Huh?
Additional district.
from the office of the District Commissioner on 1/3/2024, which was to the effect that, as per agreement, this money had not been paid by the petitioner. Accordingly, he was asked to deposit earlier his money within 1 year. Yes. There is something, I don't know, there must be some agreement, something. Mr. S.R. Barwa appearing for
That's number 2 and 3.
the point number 2 and 3, and Mr. P. Sharma for the fishery department. Submit that they will obtain instruction regarding the above. Accordingly, let this matter after the due vacation.
Indian Miller, the next 7 they can be.
When can you bring that information?
What is extra copy?
Extra copies, extra copies of the writ petition be provided to the respondent council. No, anyway, when can you bring it for instruction? Huh?
Before you,
Then the first week? Yes,
ninth of April. 9th of April.
9 to 5. Yeah, 5. Please the matter of 5.
9, 10.
Same matter, representation dates also same. Fishery is same or what?
Only name is different.
Fishery name will be different.
Man,
Huh? Person name is different, but person name is not reflected in the order. So let us see the fishery name. Same out here. I'm quite sure we'll learn quite a few things the next time. Number 17, Jamuna fishery. Okay. Then all the representation dates are same.
Yes.
Huh?
Same.
Same.
Well, same. We'll put
Okay, again, same thing. I will.
amount is not, there was not 3,265 and here is not amount 4,900.
Okay, amount is 4.
For installment 4,900 and this money is not 6,000. Okay, deposit is not, that is all.
No, I will see. I will do that. Yeah, confusing. I will give the correction.
The blacklisting order against the Pechana company was passed by a Losik. So therefore we approached your Losik Malad because in the portal our names were not removed. Then your Losik Malad by the order at page 55 Malad, the operative portion is at page 60. Malad directed them to remove the names in the from the portal. There are 10.
So any decision taken by them?
But yes, Malad, that has been removed. Page 62, Malad, that has been removed by them.
No, that is a different thing. Removal is a different thing.
Now, my lord, what happened? In view of the pending order, my lord, our 2 EMDs has been, my lord, kept posted by the rights. We have filed repression now, they are not paid. In 2 tenders, we submitted EMDs. In view of the pending order, my lord, they accepted. Pending order has been, my lord, interfered by your.
Yes, any decision taken by the railway board.
Yes, my lord, the banning order has been removed. The banning was in respect of a different contract, my lord. And the petitioner now, the EMD which the petitioners are claiming, is in respect of contract executed at Orissa and Ranchi. My lord, so this is no territorial jurisdiction, my lord. The claim which the petitioners are making is in respect of a contract pertaining to Orissa and Ranchi. All the
Okay.
representations, my lord, at page 65 and 76 is all addressed to a different state, my lord. But it's the banning order only, my lord. The banning order is in different contract. That is in different contract. Banning order.
They're not banned here.
No. There it was a joint venture, my lord. Now,
Out here they're not banned. When is your case?
only because of the banning order, my lord, they have kept it.
They kept what?
They have kept these EMDs, my lord. They have not settled the contract with us because our company was banned.
But that you go there, you go to the Orissa High Court.
That is not the question, my lord. Because of banning order, my lord, they have done it.
How do you say that because the banning order?
Yes.
How do you prove that?
Yes.
my lord, at page 65, my lord, your lordship. This is your letter. Yes, my letter. It is said that the order of banning has been satisfied by the Guwahati High Court and has been revoked by the Railway Board. To the state, my lord. So prior to issuance of the above mentioned so the rights issued a letter hearing number 22 that the endured Honorable Guwahati High Court ordered the name of the one of the Ben Farm Sumkon that so has been deleted from the Ben vendors, the state letter. Therefore, under fashion, they humbly requested the amount of so in connection with NIT should be refunded to us. That's it. So that is, my lord, only for the banning order, madam. No, where is the banning order? There's no banning order. It's been deleted. That's it. It's been deleted from the list of banned vendors. Correct, my lord. That's it. Now, my lord, because you participated in the tender notice, yes, pertaining to Orissa. Yes, Ranchi. In Ranchi. Then where is the where is the thing that you have not been allowed to participate due to the banning order, or you have not been selected due to the banning order? Where does it say? We have not been followed. Our tender has not been cancelled because of the banning order. And that have not been cancelled? Our tender has been not been considered because of the banning order. How do, but then you put that to the Orissa High Court. But the banning order, my lord, it is rights. No, where is the rights, my lord? It is a main headquarters in Delhi, my lord, and it is everywhere. Maybe, but then the cause of action is there somewhere else, not here. There was a banning order, my lord, it isn't done. Let them take instruction, my lord, that it is not done for the banning order. There's no jurisdiction, my lord. Which is the petitioner's name, my lord? The form, petitioner form is from, my lord, see the court title. Yes. The petitioner. Page 3. Petitioner is from Kolkata, my lord. He is authorized by signatory from Orissa. And then the respondents are from, my lord, Gurugram, my lord, in Delhi, and then Lucknow and Bhubaneswar. The representation that no part of cause of action also arises. Correct. Nothing. My lord, let them take instruction. No. Right. Mainly the
Mr.
right.
Counsel, no, there's, none of the respondents are from here.
Right is the main.
Right.
Because Union of India is there, my lord. There are lots of things, my lord. Because right is a organization, my lord, where everywhere it is there. And rights, my lord, which it can be.
Maybe rights are everywhere in India.
My
So
lord.
what?
Let them take instruction, my lord, if it's not done for a banning order. Only to that extent, my lord, I'm saying, my lord, that let them take instruction that for a banning order, it has not been done. If it's done for the banning order, my lord, then everything is clear.
You go to the Ranchi High Court, the Bihar, the Patna. But this is Orissa, sorry. This is for
Orissa and
this is for Orissa. This is for Orissa.
Orissa and so, my lord, again, my lord, because the banning order is no part of cause of action in the road.
Correct. There's no cause of action.
It's a subsequent cause, my lord. Non-payment of EMD is in respect of a contract in Orissa and Ranchi. Anything take care of
It
that.
should be the right, my lord. After all, right is clear.
Okay, right. That Mr. J.S. Sahewala. Let us also for the petition to submit that the respondent right. That's point number 2. Has floated to NIT number para 2, huh? The petitioner submitted his tender in person to the above. This is two NIT. What do you mean 2 notice? This is 1 notice.
No, 2, madam. 2 from 2.
He has submitted his notice, has submitted his tender document in person to the above NIT. The petitioner's grievance is that the petitioner has not been considered. The petitioner's tender document has not been considered due to
Banning order.
the banning order dated
29/10.
21,
29, 10, 2031. Where is that?
page 24, my lord. Page 24.
Issued by the Government of India, Ministry of Railways, Railway Board. Next one. No. The petitioner sought to submit that though the petitioner by letter dated 16/10/23 had requested the respondent authority for refund of the petitioner's earnest money deposit, which was kept on hold in view of the banning of the petitioner. In this petition, in this NIT?
Yes.
In this NIT.
No,
No,
Page order is independent, I think.
Ah.
But this is a
So this refund, is for what? In this, no,
refund is another, like,
another NIT. So out here, you have not asked for refund.
Maharaj?
No. He just wants consideration of it.
Yes, only for pending order, my lord.
That
Huh?
banning order was in respect of a different contract.
But pending order is for all.
But that banning affects the entire, all over India when they apply for tender, that is affected.
Ah,
So they have applied for a tender in Odisha and
correct.
Karachi.
Ah.
There, they're asking for refund of the EMD.
Pending order is affected South India.
So you want to refund them?
Well, that is why, my lord.
Only for refund.
Only for refund of the EMD, my lord. Nothing more than that. Because my
But
tender
then
was
you have to go there. Where this
Well,
court?
well,
Nothing.
because after all, rights, my lord.
No cause of action arising in
Headquarters, my lord,
this
government of
territorial jurisdiction. my lord.
railway board has to consider it, my lord.
No, I think no, you cannot do it. Right, whatever. Huh?
Rights, my lord, the lord can.
Huh? 2023 had requested the respondent authorities for refund of the petitioner's earnest money deposit. No, earnest money deposit. The same has not been done by the respondent authority. Gupta. Mr. H. Gupta appearing for the respondent. All the respondents. No. Appearing for the respondent number
All.
1.
So I think, nothing.
Only one submits that the this petition is not maintainable as no cause of action has arisen under the Guwahati Act. So we submit that the NIT was issued in Orissa, and the
Orissa
and
Mandota.
Orissa and Ranchi. No, this is Madhya Pradesh.
Odisha and Madhya Pradesh.
In Orissa and Madhya Pradesh. And the earnest money had also been submitted in Orissa and Madhya Pradesh. Correct? In Orissa.
No, the representation made before Ranchi, page 65. Malod has already posted 76, page 76 representation. Before Odisha, will take page 65.
It's still 65.
Page 65 is the representation.
Because these are the rights, my lord, to consider. They are written
Oh, but then you have to go there.
my lord. So right, my lord, can be directed to consider it, my lord. Your lordship. Director right to consider it. That's not.
Better you go there. You cost foundation.
Different contract. Altogether different contract. Maybe different contract, my lord, but
Whatever I said. Uh, the letters written by the petition to the concerned authority also was was also in the, no, the letter is written by the petitioner for refund of the earnest money was also submitted to the regional head, not to the regional project office. No, to the huh? It writes to the senior DGM, bracket civil rights limited, regional project office, Ranchi. So, as such, the petitioner would have to approach the concerned high court where the cause of action had occurred. I have I have heard on I have perused the cause title of the writ petition, and the same shows that the petitioner is from Kolkata and signatory and the authorized signatory is from Orissa. The respondent number one is the Union of India, represented by the Secretary of Government of India, Ministry of Railways, New Delhi. Respondent number two is having its office at Gurugram, Haryana. While the respondent number three is having its office at Lucknow, UP. The respondent number four is having its office at in Bhubaneswar, Orissa. The NITs have been also been issued. When the NIT?
Two my lord.
Huh?
Paragraph.
No, but the NITs have also not been issued within the state of it. No, that have not. The NITs also pertain to works to be done in Orissa and Madhya Pradesh. And that was the matter. This court is also agreed that as no cause of action has arisen within the jurisdiction of the Guwahati High Court, the petitioner should approach the competent court having jurisdiction over the area.
On the time of the judge. Paragraph,
Over the area in which the cause of action arose.
paragraph 16. Paragraph 2014 986 329 paragraph 16. 14 329 the last bottom from the bottom three line, in order to maintain a repetition, the petitioner to establish that a legal right claimed by him has been
Right.
making the petition.
In the case of Nawal Kishore Sharma versus Union of India and others, 2014 9 SCC 329, the Supreme Court has held that in order to maintain a writ petition, the petitioner has to establish that a legal right claimed by him has been infringed by the respondent within the territorial limits of the port jurisdiction. In the present case, as the NIT pertains to work to be done in Orissa and Madhya Pradesh, and the earnest money having been deposited in respect of those work in those states. Besides, the concerned respondents being situated outside the jurisdiction of outside the state of Assam, the petitioner would have to approach the concerned high court, concerned court, within whose territorial jurisdiction the cause of action has arisen. The writ petition is as accordingly listed has not been. Then
If the petitioners are absolute owners of the land, they applied for building permission before the GMC.
item
10.
Ah.
They applied for building permission before the Guwahati
who applied?
the petitioner.
Ah.
They are the absolute owners of the land. They wanted to
They applied for building.
building. Now, the GMC is not providing me that NOC or the building permission on the strength of an impugned order that is at page 46. They say that I have to pay forest royalty at
46.
page 46.
Yes.
That in connection with this department, may I read my letter in reference to that I am directly to inform you that a meeting was held on so and so at so and so at conference hall of Honorable Minister Environment and Forest Department. And so with an official from both departments to discuss issue difficulties faced by various departments in collection of forest royalty on minor minerals used for works of government departments, private builders. After discussion, it was advised that no changes be effected in the notification dated so and so. And so as such, notification will be applicable in realization of forest royalties in both government departments, urban local bodies for both government and private agencies until further on. Now, private agencies, they have included. Now, as per the Act, the leaseholders who extract minor minerals from those mahaldars, they have to pay for it. And in terms of the Assam rule, Assam minor mineral concession rule, the government department, either it is central or state government or urban local bodies, they have to pay royalty for extracting.
So where is the notification?
Notification I have it. Page 38. That is the amendment of the rule.
The 21 notification.
Yes, but
38.
38 is this is
The later one, no?
yes.
This is no, where is the 710?
710, my lord. 710 I have amended rule. Page 38.
38 is 710. Huh?
Yes, 710. That amendment of rule 5.
Good, 5. Yes.
Rule 5. Then they have included 3.1. The minor minerals when shall be used or consumed by government department. The rates of royalties shall be paid as per the rules prescribed in the third schedule appended to this. Then second paragraph, my lord, the minor minerals when shall be used or consumed by government agencies. The rates and loyalties shall be deducted as per the rules prescribed the third schedule appended to this rule, and other agency ancillary charges as shall be notified by the government at the time of procurement of bills, payment of bills of contractors or suppliers in proportionate rate to the percentage of the
So there were no royalties payable for
Payable
private
by private,
as
private.
per the 710.
yes, and they by that impugned letter,
Okay.
they are extending the horizon that they cannot,
They cannot, why not?
because that's a statutory rule, man. The rule envisages that
It is-
either the
It is not superseding.
no, the private individuals are not included.
And the coordinate bench of the honorable court. I have-
They have, what have they said? That as per this rule, they have said, what have they said?
Yes,
No, huh?
as per the rule. Now they say. After discussion, it was advised,
That no changes be made in the notification.
and then notification,
Notification means this page 38.
page 30.
Huh.
And then say that the subsequent paragraph, as such, the notification will be applicable in realization of forest royalties in both government.
Okay. So there's a contradiction between these.
And the similar order passed by the honorable court at page 51. That interim order has been passed. Three orders I have in it. Last one is page 51. It starts from also not 51 minus, it's 57 minus. It starts from 55. 57 paragraph 5.
Anyway, so yes. Let's see the picture. It apparently, I mean, this notification is not in consonance with the rule.
Not to like, I mean, this not to fix with the main case.
It is so clear, perfectly apparent. I mean, what is there to examine? Unless your eyesight is so bad that you can't read.
More than 50 cases, more than 30 cases are there. And they are all pending. And but still, to notice and allow the TMC to issue the. I mean, not to fix with the main case, that is 20.
I think we tag all these cases and finish it up at one go.
So they are all checked with the main case. That is
That
what
is
will
fixed on 10-5.
I listed on 10.
it will
10 5.
10-5.
May.
Yes,
all notice has been
page 51.
page 49 notifiable. This is the main case.
Yes, 49 is the
Petition
main
number 204020.
Okay, anyway. Right, third Mr.
case. A.
A. Bhattacharya. Learned counsel for the petition to submit that the letter dated 2/3/23 issued by the Joint Secretary to the Government of Assam, Mines and Mineral Department is not in consonance with the Assam Minor Mineral Protection Bracket Amendment, Rules 2021. Inasmuch as the rules do not provide for payment of royalty by private agents,
Agency individual.
private individuals. Issue notice returnable in 4 weeks. Mr. R. Bora accepts notice on behalf of
But I, as per our notice, we have
As
the
per our-
number CN6.
PSP, Ms. M. Kalita. 1 and 2. And S.R. Parva for 4 and 5. 4 and 5. List the matter on 10/5 along with WPC number
204.
2040-2023. Till then, the letter dated 2/3/2023, insofar as it relates to payment of royalty by private individuals, shall remain same. That's all.
And the petitioner's NOC may be
And the petitioner's NOC may be issued by the concerned authority.
applied. NOC for building firm.
Huh?
NOC for building firm.
NOC for building. For building. Item?
11, but similar.
Okay. Okay. Done.
Item
Allowed. 12 also allowed. Acha, wait. Miss A. Loda for 2 to 6. And you are Miss P. Rabha on behalf of Miss A. Gyan for point number 1. Huh?
Item 20
No, I think those are different. I think that I has to be allowed first.
here.
Offline.
What? 10, 11, 11 and 12, 11 and 12. 11, 12 finished. 14.
This concerns the non-dispersal of
So any admission? Where's the admission? So what is to be done?
bill amounts are there. Has the notice been
How much is the amount claimed? 1470, 712.
yes, Lord.
No, don't say yes. Confirm it first.
Also, Your Lordship, the work orders are of the year 2046. There is also a ground of defect
That is why they've come here.
after 8 years.
But what to do? It's not their fault that they're not being paid.
I have to get the instruction.
Okay, right, Miss B. Chowdhury, Senate counsel for the petitioner submit that the petitioner has not been paid his contractual bill amounting to rupees 14,70,71. Issue notice returnable in 4 weeks. Ms. M. Kalita accepts notice on behalf of
Respondent one. All the,
all the respondents. This is a matter of the police to enable the respondent counsel to obtain instructions and file affidavit if necessary.
wait, like.
May I please your lordship? My lord, I have applied for tender. I have applied for tender procedure market settlement
Tender dated
17/1/2024.
17/1/24 then.
Altogether 5 tenders applied. 3 withdrawn, only 2 remain. And a preliminary order has been issued to the H1 bidder. I am not the H1 bidder. But the H1 bidder has not submitted the financially sound certificate and he has not signed all the documents in the tender.
He has not signed the document
Documents. He has cited
and
the
financially sound.
clause number 4 and clause number 7 of the tender document. That's the next one page.
So has the tender been settled with him already?
A preliminary order has been issued to him. My only prayer is my that record will be examined by her. Until then, I am the existing bidder.
Maybe, but we don't know. That's an allegation. On the allegation, unless there is some kind of prima facie proof here, how can we just say a
But
tender process?
and we have submitted 2 representations also.
Maybe.
And that has not
Maybe.
been disclosed.
You know the judgment of the Supreme Court.
Record to be examined on 1st of April, the tender new.
I don't know. Right, third Mr.
P. Chaudhary.
P. Chowdhury, learned counsel for the petitioner who submits that the petitioner participated in a tender process on the basis of a NIT
And I,
dated 17/1/2024. For what?
for settlement of market of boulder, stone, sand, soil,
For settlement of a market of boulders, stones, sand, soil, etc. Out of the 5 bidders, only the petitioner and the respondent number 6 were found to be valid. However, the respondent number 6, who was H1, has been selected,
preliminary order.
has been issued a preliminary order for settlement of the market. He submits that the financial stability certificate had not been submitted by the respondent number 6, and neither did the respondent number 6 sign all the pages of the tender document, some of which was a mandatory condition of the terms and conditions of the NIT. He accordingly submits that the tender cannot be settled. The market cannot be settled with the respondent number 6. This is our Barwa, the counsel for
I am for resolution number 123.
123.
It has been issued by the Kolkata Municipal.
Oh.
You have to accept.
Okay, before that is this side. Issue notice returnable in 2 weeks. This SR Barwa is the notice from the 1 to 3. So submits that
NIT
that
has
the
been issued.
that the market is to be settled by the respondent number 4 and 5.
Yes.
Pusta. Petitioner will take steps for service of notice upon the respondent number 4, 5, and 6 by registered post with AD within the course of the day. By today.
Yes.
Pusta. In addition to the above, the petitioner can also serve notice upon the respondent number 4, 5, and 6 to dusty service and file affidavit of service within 10 days. List the matter on when. When can you bring the report?
That will be for us. That will be processed by the board.
Okay, by the other side. List the matter on third. List the matter on third. From on which date the respondents number 4 and 5. Here, 4 and 5 can produce the report. But they are not here. Only 4 and 5 can produce the report. Listen,
They will
For-
get the order.
the lead job. 6 is the private response. 4 and 5.
Till then,
And just right. Notice is also issued on the interim prayer made by the petitioner. Item. So you are on this side.
Lordship, but I have resigned for the government advocate.
Huh?
Last month I have resigned from the government advocate. I'm just pending counsel from some other department, but your government I have resigned so that I can appear for this side. Lordship,
More money this side.
I want to appear from this side also.
Good.
Meet with your lordship. Lordship, the petitioner participated in the tender process issued by the district administration Lakhimpur for grant of an IMSL job. Lordship, the petitioner earlier approached this honorable court and withdrew this petition by the lordship has got us liberty to file a prayer. The lordship may kindly have a look the page 17, repeat for a moment, page 56. The repeat I have participated, page 56 for a moment.
Yes.
56, yes, my lord. The notice inviting the lordship, this is the relevant is, the my shop is under lordship, the LKP 13. LKP 13 is trail number 5, my lord.
Yes.
CD road. And the last line, my lord, for details, please refer to the previous bid document. Lordship may kindly note, they have in a repeat, they have written, we have to refer the previous bid. That was quoted on 2012-2023. And
No, okay. So just a minute.
my lord,
So the earlier bid, the earlier NIT was what? NIB was
plotted on 2012-2023.
2012-23.
Lordship.
And subsequent bid was
Subsequent bid was plotted 23 to 2024.
23 to 24.
Four.
Now, why did they submit? Why did they retender it?
It is the same grant of same job that.
No. Why?
Why? Because no one has participated in the earlier tendering process.
Okay, no one.
So they have repeated
Now, how many have participated?
participant. There are lordship may kindly have a look page 171 for a moment. One 71.
One 71.
Okay.
Yes.
There is 14 numbers who have participated, and my name is reflected in serial number 7, my lord.
Yes.
171. Lordship serial number 7, Simanto Gogoi, my lord. And site plan not countersigned by the executive engineer, assistant engineer, PWD building, then violated point 22.3 of bid document, my lord. The lordship may kindly have a look the point for the rejection point that they have stated in the bid document. They have in the rebid process, they have stated that we have to follow the earlier bid document, earlier conditions. And my lord may kindly have a look page
No,
123.
page
123. The bid document, sir. The bid document, the relevant portion for rejection of my bid is point number 6.2.9, my lord. 123, my lord, got it, sir?
124 rupees.
123, sir. 6.2.9, my lord.
Yes, 124.
Description of the site on which the proposed work is to be set up, enclosed site plan. They have only mentioned we have to enclose the site plan. Nothing is mentioned in the bid documents, my lord.
Rather signing.
Lordship. Then lordship may kindly have a look. Point 22.3, the other rejection region they have given in the rejection sheet, my lord. 22.3. It is lordship in page 134.
22.3.
It is in page 134.
Yes,
Lordship, may I read, my lord? Point 22.3.
yes.
No bidder shall contact any member of the technical bid committee on any matter relating to its bid from time to time, the opening of bids to the time of issue of the letter of acceptance (LOA). Any effort of the bidder to influence the tender bid committee in its decision in respect of bid evaluation, bid comparison of issue of the letter of acceptance (LOA) shall be result in the rejection of the bid and forfeiture of the EMD. Lordship, they have rejected my tender under 22.3, but at the same time, they have returned my EMD on 14th. The respondent cannot blow hot and cold at the same time, my lord. They have rejected under 22.3. I never contacted anyone, my lord, for granting me the shop, lordship. I never contacted. I have denied.
But that is a question of fact.
Lordship, I agree, my lord, but they have returned my EMD.
So you're lucky.
No, lordship, they cannot arbitrarily done all this.
Why not? You're lucky. They made a mistake. Give it back to them.
But they have
Then it will be, if you give it back to them, then matter solved, issue solved.
Lordship, you should not like that, my lord. They have
Why did you give it back why did you give the money back?
My lord, there are two grounds of rejection. One is, my lord, one is that the site plan is not proper as per tender document.
No, site plan was not signed.
Yes,
That's
not
it.
proper.
Doesn't say, that doesn't say, where does it say not proper? You cannot put words where
It
they
was
run.
signed, but not signed as per guidelines.
Where does it say as per guideline?
Page number, my lord, 56, my lord. 56. Appended to 56, there's a page 57, which says document 57, my lord. It's a part of the 56 and 57. 57 documents to be submitted along with the technical bid.
Page 56, yes,
57, not
57, yeah.
57. There's a point 22, my lord.
Page 57,
Point 22.
point 20.
It says, well, a site plan duly signed by assistant executive engineer. So this bid was found in deviation of that. It was a ground of rejection. So going by simplicity by that, well, there's a clause, if a bidder is found ineligible, my lord, that money will be returned, EMD will be. So, my lord, going by that clause, it was returned. And secondly, by the other allegations, my lord, there is a letter from the officer whom purportedly the petitioner tried to influence, the finance and accounts officer. He has written a letter to the DC, to the superintendent, that I have been contacted and I have been intimated to favor the certain person. Though it doesn't name, my lord. So this is the issue.
But you shouldn't have returned the money.
Hello?
You shouldn't have returned the money.
4.2 is also of bid document, lordship, 4.2 of bid document at page 25.
Page 20?
5. Concluding bottom part, my lord, this EMD will be defunded.
Yes.
25 minutes, 4.2. This EMD will be refunded if the bidder does not win the bid. Keeping aside, my lord, this aspect, this allegation and counter allegation, my lord, the petitioner did not
Site plan does not sign.
yes, and my lord, it's not only the
Lordship,
petitioner
page
who was
56 then. Page 56, their letter only. We are following their order. Page 56. For details, please refer to the previous bid document.
No, so this will be there in the earlier also.
No, Lordship.
Huh?
No, Lordship. This
This,
is
this
the
document to be submitted, this page 57 was not part of the earlier.
the earlier document.
no. Yes, my lord, because the 57 earlier bid, my lord, 56, my lord, will see the clause they are harping upon, my lord. It was very vague that what you should submit. You should submit to the site plan. To clarify the position further, my lord, 57, the rebid, my lord, we addendum, my lord, that you submit a plan. which is
Okay, in the
certified-
rebid it was there.
Yes.
So it was part of the,
Yes.
it was part of the
Second
rebid,
rebid.
including the, that's what they're saying.
Yes, Lordship, but they have really,
This is, this is, and you have annexed it, not them.
I have an ex because I have to come before
Because it was-
honorable
yes.
with clean hand, my lord.
Yeah, and you have come for clean
Yes,
hand,
because they have
and you have shot
written,
yourself at the foot.
for details, please refer to the previous bid document.
Agreed,
That's why we have submitted all
agreed,
the
madam,
documents.
but this was also part of the case,
Earlier bid, it was not a part of the bid.
maybe. So what they're saying is that besides what is there in this NIT,
Sure.
you please look into the other document, the other conditions that were in the earlier NIT.
Sure.
It has to be read together.
Then Lordship may kindly have a look, point 17 of their bid document, my lordship. It's page 117. 17, my lord, 132 page.
What can it look?
Compliance with the mandatory requirements.
Yeah.
All bids will be reviewed for compliance with the mandatory requirements as contained with the e-bid. Bids
Now, where are you reading? Which clause?
plus 17, my lord.
Please. Yes,
Compliance with mandatory requirements. All bids will be reviewed for compliance with the mandatory requirements as contained within the e-bid. Bids deemed non-responsive will be eliminated from further consideration. Lordship, these are all mandatory as per their earlier bid documents. We have to submit a site plan. They have not mentioned whether it should be signed by the executive engineer or assistant engineer. So we have submitted. I could have submitted a site plan signed by the executive officer, but we did not do so because there is nothing mentioned in the first page. We have to go by the earlier bid documents.
you have to go by the earlier bid document and the bid documents that are there in the second bid.
But this line does
Second
not
tender
indicate, Lordship. For details, please refer to the previous bid document and follow the revised timeline as given below. Only they have to mention and the follow revised timeline.
Then where did you get this from? This is in your petition. This is not from
Lord,
there.
I have submitted because I have to,
And this is there.
Lordship, I understand, but Lordship, this line,
Unfortunately, madam, now you are on this side. So you know, you knew what was lacking. You have made the same mistake also.
but Lordship, the other thing, 22.3, they have rejected my,
One is enough, madam. One is enough. One violation of one condition is enough.
Lordship, we have submitted the site plan signed by the assistant engineer. They say it should, we have submitted the site plan
By
signed
the-
by the assistant engineer.
It is signed by the assistant executive agent.
Executive, yes, Lordship, I could have submitted the site plan signed by the executive engineer, but for this reason only, my lord.
What was the document you were reading just now? Page?
Page 56, the repeat,
No, not that. Just now you are saying that they'll be rejected, the documents will be rejected.
yes, 171, my lord, is it? The
171.
comparative statement, my lord, 170.
No, not that, not that.
132, my lord.
Comparative statement, 171, my lord.
No, not that.
0.17 of 132.
132.70, yes. Compliance with mandatory requirements. All bids will be reviewed for compliance with the mandatory requirements as contained within this bid. Bid deemed non-responsive will be eliminated. Okay.
17 years, compliance of mandatory requirements.
No matter.
And the other
Okay.
restriction order ground is the matter of fact that I understand, my lord. Hello, at this stage, my lord may issue this, they will come up with instructions.
No.
Well-
Why should we? Why should we burden the registry? You forgot to look at page 57. You were concentrating on 56 only.
56, lordship, they have done something error, lordship, because they have mentioned we have to go by the earlier bid document. In the earlier bid, nothing is mentioned whether it should be signed by the assistant engineer or it should be signed by the executive engineer. In the additional page of the rebid, they have annexed it to this one. But in the page 56,
So it
they
has to be
written-
read together, madam. There has to be a harmonious construction of those conditions and the present condition. That's the
They
only.
understand.
Otherwise, what would be the purpose of putting this if it was going to be useless?
Lordship, my humble submission before my lord is that my technical bit may be considered responsive because I have also submitted the site plan signed by the assistant executive engineer.
Sorry.
Annexes, lordship,
yeah,
the
yeah,
site plan,
page-
my lord may kindly have a look once, my
Yeah,
lord.
you should not have, you have still you have put this page 57. This is the bullet against you.
Lordship, I understand, but I have to, my lord.
Right. So I'll have to dismiss that case.
Lordship, my page 164 for a moment, my lord. This is the site plan, my
Oh,
lord,
yeah.
because of their error, I am suffering, my lord.
I,
Only my submission is-
supposing you were this side, what would you say?
I understand, my lord. But my site plan is signed by the assistant executive engineer, lordship.
No,
Assistant engineer, PWD,
Assistant engineer. That's what, assistant engineer and executive engineer different.
different. I understand, my lord. That I understand, but they have committed that error in the rebid process, my lord.
Then you challenge the provision.
I will challenge, my lord.
Okay, right. Third Miss MD Bora, learned counsel for the petition to submit that the disqualification of the petitioner's technical bit by the technical bid evaluation committee should be set aside as there is no infirmity in the technical bid submitted by the petitioner. The petitioner's case in brief is that persons the state respondents had issued a notice inviting tender, a notice inviting e-bid, notice inviting bid dated 20/12/23 for grant of IMFL retail off license for various places in Lakhimpur district, including shop number LKP 13 at CD Road, Lakhimpur. As there were no participants for the said bid, for the said tender notice, the same was cancelled and a subsequent notice inviting e-bid dated 23/2/2024 was issued by the report. The petitioner's technical bid was disqualified on two grounds. That is, one, site plan not countersigned by the executive engineer slash assistant executive engineer of PWD. PWD bracket P. Number two, violated point 22.3 of the law.
My lord, sorry, my lord, I may also point out one thing, my lord, page 146, their bid documents, the part of their bid documents, my lord. 146.
Yeah.
Column number 12, my lord.
Yes.
Site information. Site plan certified by an engineer. This is their bid document. Nothing mentioned whether it should be executive engineer and assistant engineer.
But then in one they have clarified.
They have not clarified, lordship. This is not the clarification because this is the bid documents they have uploaded in the website. We have to download it, these documents only. They have only plotted. In fact, the lordship, there is error in the plotting retender process also because the earlier tender was to the district commissioner.
Okay, supposing we leave this for examination.
Lordship.
What about the aspect of you approaching one of the officials?
I never approached any of the
Now,
officers for
now, they have submitted a letter
lordship.
issued by this person, Finance and Accounts Officer, DC office,
Lordship.
which is to the opposite effect.
Lordship. They may take legal action there. They may
No,
file
no,
FIR
no,
against
no.
me if I have approached them.
Please listen, please listen. So that is one ground.
Yes.
As per 22.3, that is one ground for disqualifying a bid.
My lord.
Now you say that you did not approach.
Lordship.
This person says that you approach.
Yes.
Now what is this court going to do?
We will approach the civil court. Definitely. If
Eh.
only that ground lordship may interfere. I have no objection, but in the bid document itself, in the e-bid process, they have to clearly clarify what should the document they have to submit.
Now, if you approach the civil court,
Lordship.
you cannot keep can you keep the issue pending?
Lordship, it is not public accident. It's a matter of only grant of IMFL license. Or any construction work or nothing else.
Yes,
my
yes,
lord.
my lord, it's 226, my lord, no fundamental right in my lord, liquor.
Lord.
That's extra commercial.
But they have
Yardstick is to be
be
fair,
very
my lord,
clear.
they're fair, my lord. Very vigilantly, they had this repeat, it was a part of that document. That's all.
But in the bid, their bid only. It is an engineer. They
This
have
is a
written
writ petition, madam. How can
Madam,
how can I decide whether you are wrong, you are right?
the lordship may grant us liberty approach the appropriate authority. That lordship may kindly observe.
That we can do.
My lord, I will do, my lord.
But what about the first part? What about the first part?
First part, that documents lordship. This is one
That engineer. Yes, yes, Mr. Gogoi, what about this engineer portion?
engineer.
Site
It's
information,
already very
page
clear.
146.
This is very clarified. One has to, one vigilantly, one.
No, but then you are giving three types of interpretation.
No, well,
In para 146, you have not clarified. You have not stated that it should be by an executive engineer. You just said by an engineer.
these has to be drawn from this. When
How do we
my lord,
do we
when
draw
a
this?
tenderer, my lord, buys a tender document, this is a part. When he goes to this, it has to be discerned that he is vigilant enough, he knows when he says engineer, that engineer part has to be defined from this. This 20 to
That
define.
is not a definition, Mr. Kaur. That is not.
I'm not going by dictionary meaning, but this meaning of this engineer will be this engineer, nobody else.
No, lordship. Nylor's judgment, recent judgment, Niharika Enterprise matter, lordship, that medical tender matter, lordship has done rightly observe all these things. There should be fairness, there should be transparency, there should be openness in dealing with tender process. Lordship has cited the Dotpa Associate case of the Honorable Apex Court in this case.
No, that's different. That's a different concept. That's why different.
So they have to be clear because in your page 146,
That association basically speaks of criteria. There cannot be a hidden criteria or a subsequent different criteria that can be applied, which is not reflected in the tender note. That is on a different footing.
similar method 146, they have written engineer, signed by the engineer. I have submitted the document signed by an assistant engineer, not by an executive engineer. Now they are rejecting my bid on that ground only. So there should be very specific.
Because in your page 57, it has been said, you should not have put that page 57. You have shot yourself in the foot.
No, lordship, but I want to be very fair.
No, I'm not saying that you should be fair. Basically, I'm saying that You knew about the page 57. That's why you have put it there. So once you have put that page 57 there, you're deemed to have known, or you're deemed to have, you should have at least read it. Okay, right.
Lordship, in the page 57, serial number 18, they have written, we have to submit annexer C, D, and E. Annexer C is the that site plan. Annexer C of the bid document. And we have we have signed the document by an assistant executive, assistant engineer. They arbitrarily reject my tender, Lordship. My only contention, my lord, may kindly ask them to open my financial bid. If I am not a valid high bidder,
There's the other ground also. Yes, you're denial.
I never
Now-
accuse anyone.
Huh?
Because they only one thing, Lordship, the time of the opening of the tender was on 13. It was on 5/3, Lordship, but it was not open. I went to the office and asked someone else in the office why this tender was not open today. That they have shouted on me, Lordship. Only that much, my lord.
But there
It
is a-
it should be okay. As per the repeat notice, Lordship, it should be open.
Madam, I'm giving you this much space because I've hardly seen you this side.
I'm so obliged.
But then the problem is
Okay.
that this complaint is there. And you know, in a writ petition, we cannot decide disputed
Okay.
questions of fact.
Lordship, may kindly observe all those. That is my humble submission. I know my limitation in this matter, my lord.
Right. What have I said? Good stuff. The petitioner's counsel submit that in terms of the NIB dated 23 to 2024, the bid, the tender document to be submitted by the tenderer were to be as per the previous bid document required to be submitted in terms of the earlier tender notice dated 20/12/22. As there was no requirement of an assistant executive engineer to cite a site plan in terms of the earlier tender notice dated 20/12/22. The petitioner had submitted the site plan signed by an assistant engineer and not by an assistant executive.
Thank you.
He further submits that in terms of what is that? The clause assembly 70, para 17.
17 page, Lordship, 134.
No, not that. 136.
Mandatory one, my lord.
That other one where it says that it is the site plan.
Right, that Lordship in page 123, big document.
He further submits that
It's 6.2.9, page 126. 124. Lordship.
he further submits that. No, it was given that site plan, not the way it was not stated that it has to be signed by the executive engineer.
Yes, 6.2.9, descript from the site on
It's-
which the proposed
Page-
shop is to be set up, enclosed site plan.
Okay.
Submits that
124.
as per clause 6.2.9
Sure.
of the
Of the bid document.
bid document. Comma. The description of the site plan did not require the signature of the assistant executive engineer or executive engineer. Another document you showed me. page 140 something.
Lordship, 22.3. Mandatory clause, my lord. 146, my lord, 146 of the bid, there annexes of the bid document. 146, serial number 12, my
Further.
lord.
Serial number 12
Lordship,
of Annexure C of the bid document
lordship,
relating to the checklist of bidder eligibility criteria in technical bid, comma, only require that the site plan should be certified by an engineer. Accordingly, submit that as the site plan submitted by the petitioner has been certified by an assistant engineer. There was no infirmity. No, the petitioner's technical bid should not have been disqualified on the ground that the same had not been signed. The site plan had not been signed by executive engineer, by assistant executive. Next, para 22.3
page
of the
134.
of the bid document. The clause, that's the para. Of the clause that, states that any effort by a bidder to influence the tender slash bid committee or others connected in the process of examination, comma, clarification, comma, evaluation and comparison of bids, comma, may result in the rejection of his bid. No, sorry, that is that's para 22.2. Uh, cut that. States that no bidder shall contact any member of the tender slash bid committee on any matter relating to its bid, comma, from the time of opening of bids to the time of issue of the letter of acceptance, LOA. Full stop. Any effort of the bidder to influence the tender slash bid committee in its decision in respect of bid evaluation, from a bid comparison or issue of the letter of acceptance shall result in the rejection of the bid and forfeiture. At page 134.
Lordship, my lord.
Just a minute. Um, next. Mr. B. Over. Mr. B. Over, the learned counsel for the excise department, on the other hand, submits that while the bid document in relation to the tender notice dated, it's dated 2012-2023, did not require the site plan to be signed by assistant executive engineer. Correct?
It's required to be signed.
No, in the earlier bid document,
Earlier bid.
comma, the same was required to be signed in the present NIB dated 23 to 2020. He further submits that the the petitioner has tried to influence. No, it further submits that the petitioner had violated clause 22.3 of the bid document, as the same has been as one but
Finance and account officer.
as one finance and accounts officer from a DC's office Lakshipur has written a letter to the effect that the petitioner had contacted him and tried to influence came regarding the bid submitted by the petition by letter dated 6/3/2020. Next up, I have set the land council for the past. No, don't say that. You just say, on considering the stand of the petition regarding the fact that the site plan submitted by the petitioner did not contain the signature of the assistant executive engineer / executive engineer. This court prima facie finds that the petitioner has not followed the requirement of the terms and conditions of the NIP data 23/2020. On the other hand, in respect of violation of clause 22.3 of the tender document, it is not known as to whether the finance and account officer, DC's office, who has submitted the complaint regarding complaint dated 26/2024 regarding the petitioner trying to influence the outcome of the bidding process. He is a member of the
He- he's
tender
a member.
/ bid committee.
He's a member.
He is a member from where?
Page 24, madam. Page 24 of the petition. Page 24, he's a member. Member of the bid committee. Serial number 3.
He's a member, madam.
He is a member.
He's a
Madam,
member.
Finance and accounts officer, DP's office, 34.
24. Okay, he is a member. Then?
But-
But what has he said here? Let's read. Just read. So that he'll know.
With reference to the subject you cited above, I would like to report acts of interference in connection with the bids pertaining to IMFL on license, off license. I would like to report to you that one of the bidders had come with 2 other individuals on evening of 5th March 2024. One of the 2 individuals who accompanied the bidder had displayed indecent behavior and somewhat pressurized me for accepting the bid, stating that if this time the concerned bidder's technical bid is not qualified, they will move forward. Such actions are unwelcome and violate the spirit of the tender evaluation. This is both disrespectful to the committee members and violation in terms of the bid. I would like to inform you that it is clearly mentioned in point 22.3 that no bidder shall contact any member of the tender bid document committee, and any effort of the bidder to influence the tender / bid committee shall result in rejection of the bid. As such action by the individual who has no direct association with the bid is demoralizing and unacceptable. I would also like to point out that as claimed and warned by the bidder and the other individual accompanying them, that on non-acceptance of bid, they may approach the court. There's a provision in Assam Public Procurement Act of 2017, section so and so, whereby it is mentioned that aggrieved party may approach for appeal to such officer designated for the purpose. The officer will then have to dispose the appeal within 30 days. In view of the above circumstances, I would like to request your kind intervention so that tender process is carried out smoothly and as per rule without affecting independent opinion of the member.
Also,
But
my,
who is the person? Who is the person who has approached?
Just few moments ago, there was a submission from the other side that there was some alteration. They had gone to inquire there.
That is
So,
neither here.
that is the issue.
You just clarify. You just clarify. this.
No, this is the signal. I'm hopping on this.
Let him file an affidavit.
yes, my lord. Yes, my
Let
lord.
him file an
A few minutes ago, there was something.
No, no, this is, I am not.
Few minutes
saying
ago, I
that
can go.
I
can
went
go.
there to
Mr. Council, it went in here and it has gone out here.
That's a different issue, man. But
Yes.
this person has to be made a party then.
This is not a court where evidence is recorded.
Yes.
So, you see, what we do now, she thinks she's disputing that. I cannot record that.
That person
My
has to
name
be
is
made a
Sir-
party.
Huh?
He has to be made a party.
Okay, that will make a party, but then the thing, I thought that if you can file an affidavit.
Yes.
If you could file an affidavit, clear up the whole.
On his behalf, without he being a party, I filed.
Anyway, then, in that case, how can I accept this?
Yes,
Yes.
Lordship.
in the same way.
Yes, my lord.
They are modifying that.
Lordship, may
They have to, the
There is no
a
question of-
drowning man will clutch his straws, why not?
there's no question of notice, my lord. It's see, prima facie, my lord, it's a violation of the documents.
So what have I
And
said?
it's
No, it is seen that, it is seen that the finance and account officer in the DC's office is a member of the tender tax bid committee. However, on reading the letter issued, allegedly issued by the finance and account officer, who is not a party in the present date petition. Baba. It is seen that there has been no reference to the petition in person. Issue notice returnable in issue notice returnable in TV. Mr. G. Gogoi accept notice on behalf of respondent number.
but one. But it's 1 to 4.
1 to 4. Mr. S.R. Barwa accept notice on their phone number 3. Petitioner takes steps for service of notice upon the respondent number 5 by registered post with 80, which is within the course of the day.
Lordship.
In it, list the matter of the TV. In the interim, the, in the interim, the IMFL retail offline.
My lord, no interim, my lord. My lord, what about the other account, my lord? That other issue, my lord. This is materially disputed. But what about other account, my lord? They have admitted they have not signed, my lord.
This is anyway, since the model code of conduct has been issued, I don't think you're going to sub.
It may be meaningful. That is
Lordship,
enough, my
kindly
lord.
observe.
My lord, there is no
Any
case for interim, my lord.
decision
This is not a case for interim.
Without leave of this honorable court,
No, my
no
lord,
decision
how
has
can
been
that be, my
taken.
lord? They don't
Without leave of
qualify.
this honorable, I am not praying for an
They
interim order,
don't
but
qualify, my
without
lord.
leave
Okay,
leave
since
of
they're
this
not,
court.
since they're not praying, I'll not give.
Yes, ma'am.
I will, Lordship, I am praying only that without leave of
No,
this
no,
court,
how can, my lord?
no LOA has been issued.
This
No
is
LOA has been,
circumventing. This is not
without
anything
leave
like
of this court. This is
Just a
not
minute,
happening.
let me decide.
Yes, my
Lordship,
lord.
my lord,
You're like shouting so much.
I'm-
I am getting a headache.
I'm sorry,
Sorry,
my
my
lord.
lord, but prima facie,
Just a minute, Mr. Council.
My lord.
Let me decide.
Right.
And then y'all have got the scope to go in appeal. Either way. That is always up to y'all.
I'm just stating what lordship stated when he started.
Right. In the interim, the no IMFL retail off license should be issued to the private respondent without the leave of the court.
I'm
Till the
so
next
deeply
return of the
obliged.
date.
I'm so deeply
Then the
obliged,
date
my
will
lord.
fix, my lord. Then the date
Leave the matter
will fix
after the,
2 weeks, my lord.
leave the matter after 3 weeks.
I'm so deeply obliged.
Publish, my lord.
Yes, madam.
Lordship, we have the information has been shared to us that only 2F2274 has
This is what is there of, right? No one appears for the petition on call. You just take this last order, huh? Para 1. No, this is no one appears for the petition on call. Miss A. Loda appears for
response 1, 2,
1, 2, 4, 5, 6, and
7.
7. While Miss
RM for by
R.M. Barwa appears for point number 3. Then you take this last order, para 2. Next, para 3, you write, Miss A. Loda has submitted letter number PN 80 CPC, no, PN post stop 80 slash CPC slash 2013 dash 14 slash 97 dated 3/5/2023. Issued to the issued by the Executive Engineer Karimganj WR Division to the Chief Engineer bracket Legal Cell, bracket close Water Resource Department, stating that the balance amount payable to the petitioner is 12,274. In view of the above, the respondent should pay the said amount, the said admitted amount of rupees 12,274 to the petition within a period of 1 month from today. Huh? 1 month, or within a period of 1 week.
1 month will be better.
Why?
Because the finance has taken the money back from the water resources department.
Okay, within a period of 1 month from today. Next, as the petitioner has been absent on the last 2 consecutive days, now, as the petitioner has been absent on the last date also, on last date also. This court is not going further into the issue. The writ petition accordingly dismissed for non-prosecution.
By the affidavit. I changed the complexion of the case. So let me see the affidavit, you know. But I filed an affidavit in WPC 565. Let me cover all. You let me see on the affidavit.
Huh?
Affidavit of position, you know.
In which one?
In 5650. Should I take that thing? At page 151, running page.
5650.
Page 151, running page.
I don't have 151.
151.
Yes, sir. I don't have 151. Huh?
That's right. 565.
Right.
151. Filed by Ramesh Khare.
856. Affidavit of position filed by respondent number 1. 1 to 3.
Yes, sir.
In my copy, it is 66. I don't know how it is 66.
That is it. If I may,
How it cannot be 66. No, no, you see what you have tell them. This is 108.
can I check 4 million? If I may take it out.
No, it's okay. I think this is the one.
And that is the gazette notice referring to a gazette notice.
It's in this affidavit.
Yes,
Yes.
dated Milord 31st January 2020.
Yes.
On the second page, Milord,
Ah.
by this period, the Central Interest Subsidy Scheme 97 has been amended.
The central government hereby makes the 31st January 23.
My lord,
Yes.
And by this, my lord, the central investment subsidy scheme, interest subsidy 97 has been amended, your lordship.
Yes.
And
Has
this amendment shall come into effect from 18/6/2014.
Yes.
And the second phase, second ballot, the 2007 scheme has been amended.
Yes.
That has also been given effect
Where?
to the next notification. The next page. Another gazette notification.
The central interest subsidy scheme has been amended.
By Now, this has been amended to overcome the judgment of this honorable court. And the next page, you know, another amendment on the same day in the central capital interest subsidy
Just,
scheme.
just a minute.
Only for expansion.
In the next page,
Next page, 2007 policy subsidy scheme has been amended.
same thing.
This is 97,
Acha, this, yes,
2007.
correct.
And this has also been given effect to from 18/6/2014.
18/6/2004.
So, my lord, these two schemes amendments, I will have to check challenge separately. Because these amendments have been made after the scheme was not in operation at all. The scheme in 97 became was operation up to 31/3
2007.
2006, the 7th March. And then another one 7 to 17. Now this has been made in 23, so I will take challenge. But
You have to?
challenge these two separately, you know. But my lord, this amendment has come into force from 18/6/2014.
Retrospective.
Retrospective, that too from 18/6/2014.
So,
So for the periods prior to 18/6/2014, I shall be entitled to interest subsidy on the basis of the judgment of this honorable court.
Ah.
So my claim will be there that you will also but because of these declaration the direction. That's it, the amendments have come into effect from 18/6/2014. Prior to 18/6/2014, they should disclose the particular subsidy on the basis of the judgment of this honorable court. And with the liberty to meet the challenge, these notifications, this petition will. There is no difficulty with here. My capital also is up to
is 120? No. It is 120, there's, okay, 128.
here,
This one, is it this?
if I may take your lordship.
No, is it this? No.
Paragraph, if your lordship will come to paragraph 14,
Of the same affidavit,
I mean, paragraph 15, lordship.
of the same affidavit.
Yes, lordship.
Yes,
That there is a G in the next page. There's a G in the next page.
yes.
Lordship, some amount has already been disbursed. So the authority will take note of the amounts already disbursed to him. And if there is anything due. Whatever this we call for the judgment of the disbursed.
The
And
adjustment
taking
will
into
be made.
consideration, taken into consideration whatever has been paid.
So the adjustment will be made accordingly.
Well, balance amount is to pay.
The only thing is, earlier I think you were saying that what was that issue that
Because that issue,
that circular of 18/6/2014.
but this was the amendment of the scheme was not there.
Okay, this has come recently.
They have produced it only with the in the
Okay, okay, so it was not there earlier.
my lord. Earlier only the clarification was there, the cabinet approval was there only.
Okay, okay.
So we are arguing on that basis. Now on the from the affidavit we have come to know that these schemes have been amended. So Lordship asked me question whether the implementation has been done or not of this. So now, the schemes have been amended. So by that, those arguments will not survive.
So those are all gone.
At least I can use it.
Huh?
I can use this package for future. You can use it further when we challenge it also because. But
I had made some notes, some order.
there's no use now.
There's no use now. All those things,
And I will also give a compilation of the
all
judgment.
gone,
Compilation of
all become useless.
I'm so thankful, Lordship, has given me an opportunity to file. Two cases without one tender matter, you Lordship heard everything in state. And here they have made payment.
But that other tender matter, I think you're going to be the indirect beneficiary.
No, because they have stayed everything.
No, but then that
Yes, ma'am.
stay, but then that during that time that period of blacklisting will expire.
But in the meantime, they have paid the division bench judgment, the single bench judgment order and all orders.
No, but then supposing
It is pending without for.
if it's pending for a year, then it goes because the factors.
In the meantime, they will try to give the allotment to somebody else.
But can they do that?
Other side, because there is no state. All orders have been stayed.
Okay.
Please, we are putting up a fight against Dr. Saraf. No, we are with the Union of India, where we are developing Union of India is very big. And with architect Chaudhary, Lordship will see that the entire petition has been paid instruction by the amendment.
Everything is gone, finished. Okay, right.
One order may pass more than all the cases.
Okay, right. Heard Dr. A. Saraf, another senior counsel for the petitioner, assisted by Mr. N. Datta. Also heard Mr. R. K. D. Chaudhary, the learned deputy SGI, appearing for the respondent numbers 1 to 3.
All my stated also.
Mr. N. Kalita appears for correspondence number 4, 5, and 6. Next para. The petitioners are challenging the inaction of the respondent in taking steps for processing and disbursing the interest subsidy claim of the petitioners under number 1, the NEIP scheme, 1997, and number 2, CISS 1997, and number 3, NEIIPP scheme 2007.
Both are 97, the Central Investment Subsidy Scheme 97.
Yes,
And
know.
Central Investment Subsidy Scheme 2000.
No, that one is NEIP 97, one is CISS, and one is NEIIPP 2000.
And that is under the.
Under the,
This is the scheme, that was the policy.
okay, which is the scheme?
The Central Interest Subsidy Scheme 1997
Okay,
and Central Investment Interest Subsidy Scheme 2000.
okay,
That is Gazette of
okay. So it will be CISS and
2007 and 97.
at 97 and 2007. So NEIP and the NEIPP are not required. Okay. The petitioners counsel submit.
Disbursement on the basis of judgment of this.
I know. Okay. So even the circular has become useless now.
The circular now we know.
So it is we go straight to this one.
So the prayer you lost me see it even simple.
Huh?
In my petition prayer.
Is it petition?
Prayer. Page 30. The page
Yes.
32.
Prayer is for
Item
disperse the subsidy.
To process and disperse the interest subsidy claim for the petitioner in terms
Internal
of
judgment is fixed.
judgment and order to dismiss.
Okay, right. The petitioner counsel submit. that a direction may be issued to the respondent to process and disburse the interest subsidy claims of the petitioner in terms of the judgment and order dated 3/6/2018 passed by this court in WPC number 2012/2014. In terms of the CISS 1997 and the CISS 2007. This time. He also submits that, no, the learned senior counsel for the petition also submits that. In view of the counter affidavit filed on behalf of the respondents number 150. Wherein the Gazette of India notification dated 31/1/2023 shows that the amendment made to the Central Interest Subsidy Scheme 1997 and Central Interest Subsidy Scheme 2007. No, the amendments made to the Central Interest, the amendments made to the Central Industry Investor Interest Subsidy Scheme 2007 and CISS 2007, 97/2007 shall come into effect from 18/6/2014, the interest that the interest subsidy payable to the petitioner should be made from 1/4/2007
For the period prior to it.
for the periods prior to 18/6/2014. Any payment already made earlier can be adjusted from the amount that is that will be payable to the petitioner. And next, Mr. R.K.D. Chaudhary, the learned deputy SDR for the respondent number 150, submits that. Also agrees with the submission made by the learned senior counsel for the petitioner and submits that the petitioner can be given the central interest subsidy in terms of the CISS 1997 and 2007 for the period prior to 18/6/2014.
In terms of the judgment of.
In terms of the judgment of this court,
In terms of the amendment. No, in terms of the amendment is against me. Amendment is against me. That's it.
in terms of the judgment, in terms of the judgment of this court in WPC number 12, keeping in view the fact that the amendment to the CISS 1997 and 2007 have been made
Effective.
effective with effect from 18/6/2000. Any subsidy paid earlier shall accordingly be adjusted to the subsidy still payable to the petition. The entire, okay. The subsidy payable to the petitioner, the interest subsidy payable to the petition shall be paid within a period of 3 months from the date of receipt of a certified copy of the subsidy.
I will often keep the liberty to challenge it.
That is always there.
Otherwise, look, because actually the person has already been filed. Like you said, not to the notice. You will not tell me difficult. You will not say.
It is needless to add that the which notification this
Even cheap becomes.
that needless to add that the petitioner has the liberty to make a challenge to the
Amendment notification.
amendment notification dated
31/1/2020.
31/1/2020.
All the.
If so advised. Huh? Two notifications. This is two notifications.
All the consent will be first.
Huh?
All the petitions will be put.
Then we pass in one single order.
One photo.
Anyway, I was expecting a lengthy argument from
I
you.
was also, I prepared after going to the affidavit, nothing is there. I don't know.
One stroke, everything gone.
I don't know in other case, one is pending. There also what affidavit things, nobody knows. I'm highly obliged, you know. My difficulty is not that when I have taken over, all files have not been given to me.
Oh.
So I do not know whether the affidavit has been, when I send the file, I don't. It is the file last time I placed the affidavit also. And get ready.
Later on, Tata, we'll just put that amendment, we'll just put it in the order of. Okay. We'll just copy paste that.
Put that.
Yeah, we'll quote that. We'll quote it, that amendment. Item, item 23.
We have filed affidavit, madam.
What is this?
Regarding non-payment of affectors.
Madam, 21.
We have filed affidavit, whether,
No, it's not on record. To what effect?
No, my love.
To what effect?
Regarding, my love, it is already admitted, my love, that, may I, much over to you, love. My love, we have admitted that, my love, amount is 11,75,000, paragraph 7, my love. 11,75,977, my love. And we have paid 1,81,720. Rest of the amount, my love, proposal has been sent, my love.
To whom?
To the, my love, Director General of Police, my love. Authority,
Okay, then we'll dispose it of.
Lordship, then, my love,
Okay, right. Ensure that the affidavit,
we have filed it, madam.
when did you file? Okay, right. Third,
Online
Mr.
Elmo.
L. Mohan, learned counsel for the petition. And Ms. Yudas, learned counsel for all the
all
respondents.
that.
The petition is aggrieved by non-payment of the hiring charges of his vehicle bearing registration number AS, it's here in the thing, it's there in the synopsis. Okay, in yellow. Two vehicles. Huh? Two vehicles bearing registration number, for an amount of rupees 11,75,977 payable by the respondent. Ms. Yuda submits that affidavit in opposition has been filed on behalf of the respondent number 4, who is the Deputy Commissioner of Police, bracket, admin, bracket close, what? Which is to the effect that while the petitioner had claimed an amount of rupees 11,75,977, on checking the records, it was found that an amount of rupees 1,81,71 has already been paid to the petitioner. The remaining balance amount would be paid to the petitioner as a proposal for the same has been sent to the Assam Police Headquarters for thanks. Correct.
My love.
Entry of the submission made by the counsel for the parties and on perusing the affidavit in opposition filed by the respondent number 4. the respondents are directed to pay to the petitioner the balance amount of rupees.
Matlab,
Yes, use your
that I
calculator.
have calculated, Matlab, that the 5 days, that is bottom, Matlab,
Amount of rupees, 9,90,256.
But-
Within a period of 4 months from the date of receipt of a certified copy.
online.
Put up, as the present, order has been made on the basis of the affidavit in opposition submitted, which has been submitted by by Miss Yudas, our registry, to ensure that the affidavit filed by Miss Yudas is based on it.
In government, Matlab, we do e-file also, e-filing. Matlab, we'll check up.
The writ petitions accordingly disposed. Picture, see, 24, 25. What is this?
Matlab, last occasion, you are asked to modify the, matlab,
Actually, just at the time of granting me the interim protection, it was noticed that the prayer portion was somehow computer problem, Lordship, I didn't know. It was deleted. So I was directed to submit a fresh claim. Now to bring a fresh claim, Lordship, it has to be miscased or
You have to
something.
mistake it.
Yes. So, Lordship, this is March, April, new financial year starts. So all the contracts, e-tendering will be starting fresh now. I'm just before this honorable court, that I may be protected in print so that I can participate in the tender process. Because I've been blacklisted for more than almost 2 years.
Blacklisting, how long can you have a blacklisting done?
But they don't know.
no, matlab, immediately, here, matlab, yes, it is as per record, matlab, that is, matlab, there is only a remark. In the, matlab, now all are e-tendering, matlab. Because of that remark, matlab, they have been blocked, matlab. There is no such order also for what, how much period of time, for 1 year, 2 years, that is, there is nothing order also. But there is a remark, because of that remark, matlab, they are unable to, that is there, matlab, but, I have shown, matlab, the prayer portion is there, nothing, matlab, in the prayer.
So you have got to correct the prayer portion.
No, Lordship, I have corrected. It's just that I have to bring it by process. I have filed it through an affidavit.
And do it
Just
as-
that few lines got deleted while maybe
Whatever
before
it is,
printing or
madam,
whatever.
whatever.
Lordship. I have also overlooked it. So Lordship, I will bring the new plain, amended plain again through a mistake since court has given me the direction also. Lordship, till then, Lordship,
Madam, it will amount to giving you the final relief.
no, Lordship,
The
only
interim.
Lordship.
It will amount to giving.
Lordship, my bread and butter, they have kicked in my stomach, Lordship. I am facing financial hardship.
Correct, madam, but then your bread and butter has been pending here for the last 2 years. Become all moldy also, madam.
Lordship, whenever it is listed, they are always it is used, Lordship. Union of India is always.
No, madam, you
Time.
see, this is the order of the court. Okay, the court has said that the prayer is not structured in the manner in which it has been, it ought to be done. Miss Bora Learned Counsel prays for a week's time to file an amended petition incorporating a proper prayer.
Only
That
the
was
prayer.
done on 7th.
Lordship, this month,
Correct. Today's what day? 22nd.
22nd.
So how many days have passed?
Lordship,
3 weeks have passed.
Lordship,
or 2
I
weeks
had
have
filed
passed.
an affidavit, Lordship.
You filed an affidavit.
Yes, Lordship.
Affidavit bringing that petition.
That is not the way.
Because Lordship,
Madam, you see, you cannot, there's a procedure.
I know, Lordship. I understand that, Lordship.
If you understand that, please
Because
follow
I
it.
was given 7 days time. And I was also thinking that.
You were given
because it was
14
month
days
of
time,
March,
in fact, 15 days time. The last time it was listed was on 7th, today is 22nd.
22nd.
So there are 14 days, 15 days time given to you. You can have easily made a small application for amendment, which would have been allowed, because this is only a irregularity. But nonetheless,
But I can,
you have to follow the procedure.
Lordship, the plaint is ready, everything is ready.
do it.
In the record also.
Then do it.
It's just that miscase I have to fight.
Madam,
I-
your case is simple, it's not difficult. But please follow the procedure. We are helpless.
Sir, Lordship, violating the whole constitution, all the articles. But cases, they are blacklisting.
Madam,
all in
all the cases that come to this court, at least most of it, at least to this court, is under Article 226.
Yes, sir.
That is violation of the fundamental right or legal right. Basically violation of the constitution. So why should your case be more different than the others?
Now, Lordship, if the respondent says that we have not blacklisted,
Just
so
submit
there
an
is no
application.
comment on the computer.
Just
but
as
that
Gaurav,
was
Learned
blacklisted.
Counsel for the petitioner shall submit an amended application. Shall submit application for amendment. Will it,
So the. Because I explained this already, I just get the problem.
submit that she'll submit an application, amended application for amendment of the rate petition. Accordingly, leave this matter. After review. You submit it, you see, if you file your application, it will come up automatically.
Second of, second of.
Okay, 2nd of April, list the matter of 2nd April.
My presence,
There is
Huh?
another
my presence, madam.
Mr. KK Parasar appears for the
selected.
respondent.
Okay, there is one more matter.
What is that?
What one petition, second item is 25 malad. That in that case, we have received written inspection malad, written inspection malad. I have to bring an affidavit malad. Regarding malad, payment of the malad expected amount, but malad here is, they have stated that.
Okay, right, in item 25, Mr. KK Parasar submits that he has received instructions and will be filing affidavit.
Malad.
Within a week,
2 week malad.
within 2 weeks. This is the matter on 2nd.
Also, we are the for director to obtain instruction. As regards the page 25 of the
What is that?
whether
Vehicle repair, the vehicle repair bill.
vehicle.
Yes, madam.
Also, I have received oral instruction from the chief saying that the budget balance amount will be included in the next financial, that is 2024 to 2025.
Will be included, but when, paid when?
Not the immediate after 31st March, that would be placed.
You have to find an affidavit, something, otherwise how do we take action?
Within what you can dispose of load.
No, because she could be in trouble also. Better to have some written, at least if she has in writing some letter or something. It's just oral, there's a problem.
Maybe she's a very poor member.
How much is your thing?
Your
claim?
is 4,11,153.
Yes, madam, what to do? Well, can you get some written instruction? At least.
Because initially, Lordship, our instruction was that the fund demand was not submitted during 2022. Because there was some instruction from the higher authority that bills prior to 2018 and not to be submitted. There was a paucity of funds. Now they have, this is my latest. That will be placed the next time.
Oh, last time also you were here. Okay, right. Miss M. Kalita, current counsel for the PhD department. Submits that. Submits on instructions. No, submits that she has received verbal instructions that the petitioner's bills would be placed in the budget for the year 2024-25 and paid accordingly. She is accordingly granted 2 weeks time to obtain written instructions from the concerned chief engineer. And so you don't even have to file an affidavit. You get oral instructions, verbal instructions from the chief engineer, no? So now written instructions on the chief.
But can it be on the 5th of April?
Okay, leave the matter. I don't know. Okay, leave the matter. Fix it. Okay.
Like, you know, the Texas matter, Jal Shakti was executed,
Okay, right.
no petitioner.
But you have got to submit the corrected cost title.
Already done.
How can you do, how can you do it before it is allowed?
I,
How can you file the corrected cost title before the IA is allowed? I heard Ms. K.K. Chowdhury, then process for the application to submit that the Union of India, Ministry of Jal Shakti, E-Governance Cell, 6th floor cabin, Shram Shakti Bhavan, Rafi Marg, New Delhi, dash 110001 should be implemented as respondent number
one,
1. 1?
one.
1 to already there, so I think it should change. It should be implemented as respondent number. As respondent number?
Respondent number 6.
Respondent number 6. Miss
Each.
D. Jain appearing for the
Oh.
respondents number 1 to 5.
Yes.
Submit that
One to
she has got no objections to the application being allowed. In view of the submissions made by the council for the party. So, Jal Shakti, is repeated as point number 6. No, what no. Registry to, no, petitioner to submit, applicant to submit, correct copy of the cost title to the registry within the course of the day. Within the course of the day. The registry shall thereafter make the necessary correction to the writ petition. I accordingly dispose of. Then in the main case, we dispose it or we wait. Okay, right. Okay, then the IA is right in the main case, right? In view of the order dated today, passed in. Order dated 22/3/2024, passed in IA civil number 527 of 2024. So it's repeated as point number 6. Who accept Miss AJ and CDC accept notice on behalf of point number. Okay, Miss yes, come. Miss AJ number 2. What's the name, madam? Miss B Raman. B Rabha. P Rabha appearing appearing on behalf of Miss AJ CDC accept notice on behalf of respond number 2. And number 6. This is the matter on when?
57.
27. No, 27 too short. Too short.
Thank
You have to do, you have to submit your corrected thing. When will you submit? All holidays are there. This is the matter on third. 3/4.
Like similar matter, no?
Item 29 same. Item 29 same. In the IA also same. Then in the main case, you're right. In view of the order dated 22/3/2024, passed in IA 716/2024. Okay. Everything is same.
41 is also
41.
softly. Okay.
41.
Lordship, Lordship, they have not filed the IA. Yes.
41, there's no IA, madam. That's why I always tell you, withdraw it, file a fresh, it becomes much easier.
I'll wait for that.
Yes. Yes, madam, we are not interested with around 500 crores or 5 crores. That's not the issue. Whether this is admitted amount or not.
We have already submitted the proposal.
That's not the issue. The petitioner is claiming 2,28,914. You submitting a proposal for 500 crores has got no relevance to it.
Including the petitioner's offer.
So is the petitioner's amount an admitted amount? That is the question.
But it's admitted because, so, in earlier, we have, in earlier that we have received one instruction there said department has now received proposal for financing sanction for an amount of 2,28,900.
That is not with us.
Doubling.
Give me that. Okay. Okay, so that is there. Then you pay this amount.
That's it, because the system is closed.
Huh?
The system where we submit the proposal in the financial department, this system is closed because the end of financial year.
Well, we'll give you some time to pay. That's all.
That's it. So we again submit after first of the financial year, 2024-25. We again resubmit the proposal. Actually, Lordship, in this petition, finance department is not a party.
Why don't you make a finance department a party? You see, the problem is this, madam. This court had already passed an order earlier. They have still not paid. Again, they have come. How many times will we do it? This is not even a contempt. This is a writ petition. But why you have to pay, madam? This cannot be allowed. The last order. No, you don't need to try your best. We'll call the officer concerned. Why is he not paying?
Lordship, they will again resubmit the proposal beginning in the next.
No, madam, we're not worried about that 500 crores or whatever you are going to submit. 5 crores. That 5 crores has got no meaning to her. Meaning to the petitioner. Petitioner wants only that 2 lakhs.
Lordship. Lordship, can they?
Huh?
Do it time.
I think we'll call this official. No point. We are wasting time.
Can they give a last time?
One last time, madam, this is only playing around with the court. Order has been passed in 2019 to verify and pay. Now they have to come in after another with another writ petition after 5 years. This is not allowed. This, huh?
For, that sounds like it.
No. Will something positive come out of it, or you're just asking for time? Because we know the limitations of a council also. If nothing is going to happen, we'll call the officer concerned. We'll call all of them.
What happened in this matter, my lord? Initially, one proposal was sent for the financial conference for the financial. It was rejected. Thereafter, we again, one new proposal, we are ready with the new proposal, my lord. But because of the year ending, my lord, finance department's website is closed, my lord, up to the next.
Okay, Mr. Council,
My
you have to keep in mind the fact
lord. Yes,
that the earlier writ petition was disposed of in 2019.
my lord. That is there, my lord. We
5
have-
years have passed.
Fine.
How many proposals have you sent? Only twice or once? How many times have you sent? What is this?
We are,
I don't
we
think.
have to accept that, my lord.
Huh?
We are.
No, it's not you. We'll call the official concern.
we are
We'll
trying
call
to-
all of them, all the secretary and all of them will call. Make them all 5, 6 of them stand in line out here. This is not acceptable.
Yes, sir. I can understand that. Some time, my lord. Immediately after the April 1st, my lord, we are going to submit.
No, you submit whatever proposal. It just 2 lakhs have to be given. That's all.
Yes, yes, yes.
Right. The petitioner has made a claim for rupees 2,84,914 as payment for a contract bill. Submitted by the petition. This court, by WPC 929, the wide order dated 12/6/2019, passed in WPC 929/2016, and directed the respondent to submit a fresh proposal amounting to rupees 2,28,914 for payment of the petitioner's contract bill to the petitioner. Within 6 weeks. No, within 8 weeks. The petitioner has now approached this court again by way of the present writ petition, stating that the amount, the contract bills of the petitioner has not been paid despite the order passed in WPC 929/2016. Next up. In the order dated 4/3/2024, this court has recorded that Ms. N. Bora, from a learned counsel for the P&RD department, had submitted letter number E-459743-7 dated 2/3/2024, issued by the Undersecretary to the Government of Assam from a P&RD department, to the effect that a proposal for sanction of rupees 2,28,914 has been made and is under process in the department, for endorsing the proposal to the Finance Department for concurrence. Pusta. The counsel for the PNRD department was to obtain status report with regard to the above. Next para. Ms. N. Bora, the learned counsel for the PNRD department has submitted letter dated 21/3/24 stating that a financial sanction proposal for an amount of rupees 5 crore has been made for payment of outstanding liability, which is to be endorsed to the finance department for the concurrence. However, due to the last date of submission of the sanction proposal for concurrence being already over, the proposal will now be resubmitted in the next financial year. Pusta. Next para. A perusal of the above fact merely goes to show that the respondents are not the least bit bothered, are not the least bit interested in complying with the orders of this court. 5 years have passed since the direction, nearly 5 years have passed since the direction passed in WPC 929/2000. So accordingly, this court is of the view that the Chief Secretary to the Government of Assam and which Deputy Commissioner? Who is the Deputy Commissioner? But out here, PNRD is not there. What is this? Why is PNRD here? Huh? Yeah. Okay, don't say Chief Secretary. You said point number 8. The Commissioner and Secretary PNRD. Commissioner, huh? What is he? What is he? The Secretary to the Government of Assam, PNRD department. And the concerned Deputy Commissioner. Is there any Deputy Commissioner? Is not made a party. Additional Deputy Commissioner made a party. And the Additional Deputy Commissioner in charge Panchayat election, District Barpeta, should be personally present on the next court date. At what time?
Holiday. Up to 26 is holiday. First week of April. After Bihu.
No, no, no. No question of Bihu, madam. On 27th. Look, you cannot play around, madam. Please tell them very seriously. If they don't bother about the court, we have to take strict action. Some lesson will have to be sent across the ranks.
At the 20.
Whatever I said. and explain as to why. And explain as to why the petitioner has not been paid his dues despite the same being despite the dues of the petitioner being admitted by the state respondent. And the order dated 12/6/2019 having clearly directed payment of the settlement in WPC number 929/2015. Lists the matter on First, huh? First April. First April. Uh, the copy of this order be furnished to Ms. N. Bora, who can communicate the same to the concerned officials for compliance. No, Madam, one thing, we don't enjoy calling them. But this is the case. Order has been passed in 2019, June, in another writ petition. And now he has filed this writ petition, will file again 23. New writ petition. To comply with that order. I mean, contempt now, you couldn't file contempt because section 20 bar is there. This type of thing is really unacceptable. And you please tell them if they don't come up with some solution, I'm going to initiate so much of contempt against them on that day. Ms. K.K. Chowdhury, that passes for the petitioner, says that she may be allowed to withdraw her petition with liberty to file a fresh. Ms. A. Loda appears for the respondent number 1 to 5. You are not here. If you want, we can put your name along with her. As a prayer, the petitioner's counsel is allowed, this petition is dismissed or withdrawn, with liberty of speech.
Okay. Content letters, was, the repetition was, stated, kindly, have a look at page number 20.
Page number,
19.
this item,
We have received an instruction from the department that the amount has been paid for this year, upcoming year's budget. I'd like to take the.
I thought it's, 3 years. The scrutiny report is come.
what is this? How much is the amount?
It is mentioned in page number 19, paragraph 2, that the claim amount of the petitioner is 15,22,112, which after their scrutiny, they have found for 11,77,746 plus the claim amount from chief traders is 2 lakhs. So its total amount is 14,34,606.
This is neither here nor there. This is just writing a letter. That's all.
It will take some time, Lord, but
Why
it's a
should it-
process, Lord. That
Why
is
should
for
it
sure.
take time? What does the court order say? When was the court order passed?
The past of 15/7/2020. And clearly it was mentioned that within 60 days from the city report, the police
Things are moving, Lord.
Based on
This will be done, Lord. So once this election process is over, we expect. the
Election
payment to be-
process will be over only in June.
For that, Lord, it will be difficult. That's it.
What is the total amount?
14,34,000.
Where is the order? Let us see.
I don't say, but
Hmm?
the court.
Page number 19. Where is the order of the court?
Court order is annexed
This,
one,
this is a contempt. So where is the order of the court?
page number 12.
Page number 12. So what is the amount, admitted amount?
14 lakhs, 34,600.
Right. The, this, the order dated 15/7/2021. Passed in WPC 4852/2020. That directed the chief engineer PhD to examine the claim of the petitioner and pay the admitted amount within 60 days from completion of the scrutiny of the claim of the petitioner. The Mr. What is it?
I bottom,
I. Bhattakur, learned counsel for the
respondent 1.
point number one, has submitted letter dated. What is the letter dated? Can't read the date.
Date is Lordship 9 March 2024.
9/3/2024, issued by the chief engineer PhD, which is to the effect that the provision in the budget for 2024-25 concerning the present case involves the principal amount related to involves the principal amount related to urban water supply scheme, which also encompasses the amount claimed by the amount pertaining to the petitioner, which is 14 rupees 14 to stop 34603 lakhs. However, the said letter also states that the procedure for fund demand may not be possible to be initiated immediately at the beginning of the new financial year. Good stuff. Next slide. It is surprising to note that despite the order dated 15/7/2021, the chief engineer PhD has issued such a letter. I think he should appear also.
Lottery give us some time, perhaps 4 weeks time or time ahead.
I don't think it's 3 years. Because it's
This is nothing. This letter says nothing at the end of the day. It just admits the amount, but says nothing.
What it says, Lordship, is because this amount was not included in last year's estimate.
Why wasn't it included in the year before the estimate? 22, 22, 23,
Ideally, that should have happened or by.
or 21, 22?
That, but now there's a specific head of.
No, but then
It
out
just-
here also it says that the procedure of fund demand may not be possible.
It says immediately the release of the account.
Immediately means what? It's a very subjective kind of, ambiguous kind of a statement.
Once our Lordship, the code of conduct goes, the department will be free to disperse its funds. That is what it is trying to say. It's also fixed.
What have I said? Has issued such a letter which is ambiguous in nature. However, as Mr.
I would.
Abbott submits that he will obtain instructions. Definitely, he will obtain instructions with positive clarity by the next date from at least the matter after the Bihu vacation. Because of these elections, also little bit of problem there, and the other is not a small amount. Very big. Huh? Huh? Data after the voting.
Yes, is your Lordship. The Lordship, in compliance to the order dated 22/1/24 in I number 3861, Lordship, the newspaper publication has been done.
Where is it? This one, this vernacular.
Page number 19.
Well, for me it was all Greek to me.
Your Lordship, it has been given in English.
Where? Acha, okay. You're for whom?
I am for the petitioner in this case, Your Lordship. The I is for.
Give me the main case. Huh? What is the main case for?
Main case is for contempt, Your Lordship. It is pertaining to an order which was passed by this Honorable High Court, Your Lordship, while dealing with one company appeal, Your Lordship. In 2013, there was a judgment passed by then the company law.
Now what to do is they have not appeared despite this notice. We await.
This is regarding the confirmation of delay, Your Lordship. The main petitioner had expired in 2021, Your Lordship, during COVID period, Your Lordship.
Then?
And his legal heir has come before Your Lordship for substitution of their main
Applicant, you mean?
application.
Applicant is the
In I number 3861 and 3862. They are the heirs of the original petitioner.
the hire.
Heirs of the original.
What do you mean hires?
Legal heirs.
Oh, heirs.
Yes. So Lordship needs to consider this interlocutory application 3861, that is for condonation of delay.
Condonation of delay in filing the.
Substitution petition.
So So notice has not gone in the contempt or what?
The main case contempt notice was issued, Your Lordship. Thereafter, there was a proposal to submit to justice service also, Your Lordship. In the meantime, the petitioner expired by the time. So the justice service could not be completed.
Okay, right. Rest is, I think you should, okay, right. Where is the condonation of delay?
Your Lordship, condonation of delay, I number 3861, Your Lordship.
361. Okay, right. This is an application under Section 5 of the Limitation Act for condoning the delay of 532 days in filing the substitution petition. By way of this petition, who are the applicant? The applicant,
Yes, Your Lordship.
who are they?
The applicant is one of the son of,
What is their names? Where are their names?
yes, Your Lordship. It is given at page paragraph 2, Your Lordship. Page
Madam,
5.
Mr. Counsel, in the cause title, you have said Sri Sumati Kumar Surana and another. You, who are there?
Yes, Your Lordship. That is a page 3, Your Lordship. In the matter of, on the death of.
You should
Sri
put their names in full.
Yes, sir. On the next page, we have given it.
Where?
Page 3, Your Lordship. Who is the applicant?
Who? This Sri Rahul Kumar.
Rahul Kumar Surat.
Rahul Kumar. What have I said? By the applicant. You said petitioner is the applicant.
That is
The applicant, Sri Rahul Kumar Surana, son of late Sumati Kumar Surana, resident of 13, Hardwood Rise, Chamaria Road, Raghav Green, flat 3B, Howrah 711101. Otherwise, just read the entire thing. I have prayed for. I have prayed for condoning the delay in filing the application for substitution. For substitution
applicant.
of their father. Father?
His father is expired.
Of their father, who is the petitioner in contempt case C 603/2009. 19. What is the cause for the delay?
But, during COVID time, Your Lordship, he expired. Thereafter, the petitioner, the applicant, had no knowledge about his case. Your Lordship. I tried to contact them. Your Lordship.
Later on you came to.
Yes, I was continuously trying for 6 months. Your Lordship. No one was taking phone. Your Lordship. Thereafter, one day,
No one was taking phone from whom? Who? You.
I tried contacting them, Your Lordship.
Them means whom? Who is them?
The
Your dead
original
father or what?
The phone number which was given to me for the petitioner, Your Lordship. On that number, no
Your
one-
petitioner is your father. That's the petitioner in the contempt case is your father or not?
Your Lordship, what is happening in this case, the applicant had no knowledge about this present case. Your Lordship. I, as an engaged counsel, tried to contact them about the status.
Please, why you talk about yourself? Who's bothered about the council?
The petitioner
We're talking
had no
about the
knowledge.
applicant. Don't talk about yourself.
Yes, sir. The petitioner had no knowledge for 500 days. There was no contact between us,
Between us meaning?
me and the applicant, and the petitioner also, who has expired.
Okay, you are saying that you are the counsel for the
For
petitioner.
the petitioner, so I tried to establish a
So,
contact.
so his son did not have any did not know
And
that
his
this case
knowledge
was
about
there.
this case, personal
And-
knowledge about.
And you
And thereafter, he has instructed me to file necessary action.
the counsel. Next time you make an application like this, don't talk about yourself, talk about the applicant. If you insert your your issues into the application, it becomes very confusing. What have I said? Of his father, of his father. So, substitution of his father in the main contempt case. Huh? C 603 2009. Next para. The applicant's counsel submits that the applicant was not aware of the pendency of contempt case C 603 of 2019 on the death of his father, who expired on
31/3/2020.
31/3/21. So further, the counsel for the applicant's father, who was conducting contempt case 603 2019, and the applicant had not been communicating, had not communicated at all. Gustav. It was due to the above reason that a delay of 532 days have occurred. Gustav. Next para. On considering the submission made by the counsel for the applicant, this court finds that sufficient cause for the delay has been made out. Accordingly, the delay is condoned. IA is accordingly allowed and disposed of. Then, where is the other IA?
3860.
Give me the IA. Correct. Third, Mr.
F and KP.
S. and KT Learned counsel for the petitioner who submits that the applicant's father, who is the petitioner in contempt case C 603/2019, expired on
31/3/2020.
31/3/21.
2021.
He accordingly prays that the applicant may be allowed to substitute his deceased father. The prayer of the applicant is allowed. The applicant is to submit a fresh copy, a corrected copy of the cause title before the registry of the. Is accordingly allowed and disposed of. Then in the main case today, in view of the order dated 22/3/2024, passed in IA and he passed in IAC 3861/2022 and 3862/2022. So, what is your name? What is the applicant's name?
Applicant to be Rahul Kumar Suran.
Rahul Kumar Surana is allowed to substitute his deceased, the deceased petitioner, who is his father.
The lordship, at page 5 of the I number
Now, next,
386, there are four legal terms. There are four legal terms. At page 5 of the I number 3860.
you did not put all the name. You put only one name. No, this is. How can you do that?
One applicant and five.
So, how can you do that? It's not the way to do it. You're causing confusion. You make a correction to your IAs. It's not the way to do it. There is only one applicant here. How can you expect four persons now to come suddenly here?
The fourth of
Cut
the fourth
cut everything. Leave this matter after 2 weeks. Okay. You do whatever you want. You want to withdraw, you withdraw. You want to, you file a separate application. You have to please make a proper application. Please ask the seniors how to do it. Okay. This is the old one. I would put, don't leave it there. Yeah, leave it to- Huh?
I'm appearing for sole respondent.
Huh?
I'm appearing for sole respondent.
Item?
We have already complied with all that.
Okay, right. I heard Mr. No, I heard Miss KK Chowdhury for the petition.
You,
Oh, sorry. Again, I mixed you up. There's something, there's, yeah, you all look slightly different, you're different, but then why, I don't know, I mixed you up. Huh? Yeah, Jai Shakti, I know, Jai Shakti, but you don't have Jai Shakti kids, no? I don't know why, you all are both wearing glasses, maybe glasses are similar or something. Okay, right, Miss Q Nanda. Heard, you just take this, last order, para 1, para 2. Okay. Then, next para, Mr. A.K. Sharma, the learned counsel for the sole respondent, has submitted a letter dated 19/3/2024 issued by the chairperson of the Bilasi Para Municipal Board, which shows that the order dated 18/11/22 passed in WPC 7337/22 has been complied. According, no, the same is made a part of the record and marked as an Annexure A. The contempt petition is accordingly closed.
But that is a 1810.
Huh?
1810.
Oh, 9th, what? 18th.
Yes. 18th of October. Original. But it's on.
Acha, 18th.
Yes.
1810, not 11. Acha, or the order dated 1810. You have out here, even, huh? Even the second paragraph. Yes, madam.
They have already paid to park us in the safe place.
Ah.
They have not mentioned about the total dimension. When this place is already allotted to someone else.
Let us see the order again.
Also, kindly come to point number 4. This today's order, 19/3 of 2020. That in view of that, you are requested to park.
Yes.
Your request, point number 4, also, that in view of that, you are requested to park your vehicles at notified parking place situated at ward number 12 of Pilasipara 4th Street. But this was already, they have paid before, but they have not mentioned any dimension for the parking place, which we have asked for in the
But
main
the-
petition of this.
But then how can, now you,
Because this
huh?
place is already
All town mother signified
this
area.
place is already allotted to someone else. The Fuller Chandra someone else.
You file a fresh writ petition there. This is a contempt. The contempt was that the representation should be decided. Now they have decided it. What is your representation? Show us your representation. Where is your representation?
Page number 10, annexure number 2.
Yes. Which one?
This is the main para,
Yeah.
above point number 1.
Huh?
Above point number 1, the main para, last but point number, line number 7. Last but not the least, the matter of the parking question, DMDs notified parking place located at ward number 12 near Bilasipara public space without mentioning the placement in clear terms, since the place is being used by another operators also. And in annex number 1 also, they have also, in the last line, they have stated us that we can park the vehicles in ward number 12, DMDs notified parking space. And the same they have stated today also.
Yes. They want to know the exact parking space.
Specifically stated that something which are notified area. In ward
Huh?
number 12, it is notified area is there for parking there.
We have already mentioned about that notified spaces, but
And
that
Madam-
was already
Madam-
allocated to someone else.
And whether they have not,
Without mentioning the placement in clear terms.
notified area is the word number 12 notified area is there for parking space of infrastructure. So, Madam, they have already allowed to park their vehicles in that particular area.
This is a notified area.
And it's a small town, Madam. It's a small town. It's a parking by the 15, 20 vehicles maybe. Park on that. Correct. Another.
You go and see if you come again. If you see, you go to this ward number 12. If they do not give you placement, then you come. You cannot have a choice of your own. It will depend upon the authorities. They'll give you where they deem it fit. Otherwise, you have to come again to the court.
Yeah, actually, they have already given it.
That
before.
agreement,
They have already given it before.
Yes, sir. Same area they have already given before.
Then
That place was already allotted to someone else, sir. So it's hard for us to park our vehicle.
No, they have not assigned that original agreement also, because it is a 21.
just a minute, just a minute. Notified parking space located over near Bilasipara public field. Then where do you want it? How big is the parking area? What is the area? Huh? How big is the area? Is it as big as the judge's field? Is it as big as this room? What is the parking area? You want a specified parking space. Please give me an idea. How big is the area? You don't know. Then how do you expect us to decide a case when you yourself don't know how big the area is? So you, you can always come again, madam, again this one.
Okay.
This way, yeah. What do you want?
Kindly please to order 9.
Where is he?
Lordship, in the present case, the contempt number 2 name to be changed. Judgment date.
Oh, it's transferred.
Yeah. it's been
Transferred out.
transferred
Yes,
to the-
file an application. Mr. Ms. A. Loda submits that the respondent number 2 has been transferred and a new incumbent has taken the place of the respondent number 2's post. The petitioner shall accordingly shall file an application for impeachment of the new incumbent. This is the matter of 2.
637 and 8.
Same, respondent number 2 now. What is it? The non-payment?
Yes, non-payment of contract with.
Since when? No. Order.
Order 22, 7,
Nine.
Why not paying?
Okay.
But you make that application. Otherwise. Till 39. Till 38. Next.
So as per Lavazima court order dated 7/12/23, service is complete in respect of response of 5 and 6. Completely FPDP has been filed by the that is very pertaining to non-payment of contextual fee amount.
Yeah, for all the respondents or what?
Mala, no, the 5 and 6 Mala, they by the Nadira Municipal Court, that we don't differ. And 6,
Okay, right. Miss Yuda appears for the respondents number 1 to 4. The office note dated 7/12, no, the proceedings of the Lavazima court dated 7/12/2023 shows that service is complete in respect of the respondent number 5 and 6. So, however, no one appears for the respondent number 5 and 6. The present case relates to non-payment of contractual bills amounting to rupees 44,41,524. Yes, what to do?
because, we said that because they have revised the administrative Mala.
Huh?
They did not prove the administrative approval before revising the scheme Mala. That was the work he has performed Mala, completed was not under the scheme, earlier scheme Mala. The municipal board has revised the scheme.
No, you file an affidavit. Have you filed affidavit?
We have
Already
filed
filed.
an affidavit Mala, but
But already Nazia Municipal Court has taken a resolution to pay the contextual fee amount, but till they have to deal today no action was taken to release for fee amount.
Where have they taken the
So,
decision to pay?
next, in our FPDP in reply logic,
Pay?
page number logic 52.
Page 52? In the rate petition?
No logic in FPDP in reply logic. Resolution number 14 logic.
Yes.
So today's meeting discussed about the SOPT work as the contextual bill amount of the 3 numbers of SOPT work has not been released to the contextual yet. In this regard, after discussion in the meeting, the board decided to release the payment against the SOPT work from the funds allocated under the 14th Finance Commission and 15th Finance Commission untied grants. The executive officer commented that he recommended contacting the higher authority for approval.
5 and 6 has taken decision. They will take.
Thereafter, logic annexer, page number 55 logic. Director of Municipal Administration has also sent a letter to the chairman executive officer Nazia logic.
We do not know. That's why they are needed.
So let them come and let them file affidavit.
Director has already logic approved
Okay, wait, there is out here. There is WS filed by respondent number 6. What is this? Who has submitted this? Huh? WS filed by respondent number 6, Executive Officer Nazira. Para 1 is admitted, Para 2 is also admitted. But this is photocopy, this is not the original certificate. They have submitted affidavit, they have submitted written statement.
Not.
The problem is they have not admitted, they have not said that this amount, they just said the bills of the petitioner should be paid.
Lordship. And here, my lord, his name is 45 lakhs, 5,000 something. And now that is 55, the direction, my lord, request has been sent for grievance of contractors, the name of the building to court. For contract value 98 lakhs 5,438. So these are to be, my lord,
But there he works also. I'm for only one.
so municipal board has to, my lord, give it.
Yes.
Is to pay, my
Let the municipal board come. This is not even a proper.
Also, kindly allow us to take the office of the
Right. On specific, the issue involves our this court is of review that notice should be again issued to the petition, to the respondent number 5. Accordingly, petitioner shall take steps for service of notice upon the respondent number 5 and 6 who does his service. This is the same after 4 weeks. Right.
But if here, respondent number 2 filed affidavit, so we have one time is
Mr. M.R. Kandakar is granted 2 weeks time to file affidavit in reply. 1 week time. This is the matter.
that's what the but
Okay, the cost, yes. We are adjourning the matter. Okay. It is also submitted, it is also submitted at the bar that the respondent number 1 has been transferred. This is the matter of the.
after 2 it may 3 days.
You first file an application for,
I
for,
have.
complete.
Similar.
Madhya Main Report.
Similar order as the other order.
Only response number 5.
Similar order as?
Pratik, in this case, response number only. Government and action of the-
1 to 4, I'm appearing, 5 and 6.
Fresh step. Fresh step.
Only for the response number 5. In response
Okay, right.
in
The petitioner shall take fresh step for service of notice upon the response number 5. For service of notice by way of the assistant. This is the matter after two. Oppose.
Full.
Full.
Apply.
Protection link to motion.
If we apply, got some permission.
Huh?
Got some permission for moving that section. What's the opportunity? And page 28 is what. This is the NIT for hiring and operation of ambulance services at Bongaon Refinery. So out of 600 petitioner got 2. So I'm not going into all these aspects, but you will kindly see page 46. Other aspects of the matter that meeting and all, I'm not going into it. 46. Petitioner is an MSME unit, small enterprise. This is the notice of award. Page 46. This is for 3 years from the date of ending over of site. This site has not been handed over yet. Please see so and so. This document. The Lordship will kindly see page 47.
Just a minute. Now, what is this? Notice of award. What do you mean by notice of award? What does it mean?
Notice initially they give the notice of award so that if you want to accept it, that is given because of this page 41. That is given because of page 41.
Yes.
Ending of contract.
Yes.
This is a split tender and will be split in 2 parts in ratio of 60-40 according to schedule of rate line 10 to 30 and 40 to 60. At the time of award splitting will be done by GEM. Negotiation if required can be conducted with L1 bidder only. However, vendor has to put for entire 100% of the job in forces. The entire work shall be split in 2 parts in ratio 60-40 for awarding to 2 bidders. Lowest bidder must be awarded with the highest portion of the work, taking into account the provisions of MSE and PM2 policy. The balance parts will be awarded to rest of the bidders subject to matching of the L1 price. In short, my lord, L1 price, I'll have to give it at the rate of L1 price. Even if L1 is there, they are not going to give whole contract to the L1. L1 will get 60% free contract and L2 will get 40% of the contract, but at the rate of L1. So this is what it means. So therefore, your lordship will kindly see page 47, original work order has been given.
So no. What is notice of award mean? That we are L1 award. It means L1 or L2?
Or to ask so that we accept it or not. Because our price is different, L1 price is different.
Okay,
So we have to match the
your rate is higher than L1.
Yes, so therefore we have to match the L1.
Okay. So that's why they give it the NOA.
Yes, that is
Yes.
why it is splitting up because they want to give it to contract 2% members, not 1%. They will not, that is the policy of the company.
So?
Yes. Now, your lordship will kindly see the work order was issued at page 50.
50.
50. Now, first your lordship will kindly page 47.
Yes.
Letter of acceptance. And page 48, I'll
This
just
is,
show.
you have accepted it.
Yes.
Then?
Then my lord, your lordship will tell you that is their format only, page 48, time period as per GEM contract. Number so and so. So GEM contract is that your lordship will get it at page 50. This is the gem contract. I am going only for the purpose of showing the date. Page 50, my lord, down below, my lord, the last paragraph. Service start date from 18 January 2024.
Where?
The last paragraph, my lord, it starts with service detail. Left hand column,
Yeah.
service start date. That is from
Yes.
18/1/24. That is the gem.
Yes.
So from 18/1/24, now the contract is for, so accordingly, my lord, we have made payment of my lord, uh, uh, 56.
Yeah.
56 and 57.
What is the security deposit or what?
Security deposit, some amount has been made.
No, what is this page 56?
Page 56 and 57, this is a deposit for the purpose of supply of the vehicle.
What deposit?
Booking vehicle. Because the ambulance, whether this is a specialized vehicle, we'll have to put the order to the force company, which is, and this will be manufactured in Maharashtra. So we are required to book it, the ambulance. So
You are going to run the ambulance.
yes, we will have to run the ambulance, we'll have to provide all the services.
No, this 2 lakhs is for what?
2 lakhs for booking amount.
Because booking.
2 lakhs, 4 lakhs.
Okay, so you have to buy this ambulance.
Ambulance, yes. 56 and 57.
So a person who doesn't have an ambulance, he can participate in the tender process or what?
No, they cannot. They will have
Right.
to buy it because it is new. I'll show the other.
No. So what I'm saying is that prior to the tender notice,
We'll have to provide particular type of ambulance, and that has.
no, prior to the tender notice, you do not need to have any ambulance with you.
Since last 20
Huh?
years. We have been doing this business since last 20 years, but the model when the.
Why is the other side not here?
So sir, Bongaigaon, sir. Bongaigaon,
Bong-
they do not have any. But I'll show one aspect, just quickly, my lord.
IOCL,
Quickly, my lord, I'll just show.
IOCL,
Not
IOCL,
ISL, Bongaigaon refinery. 56 and 57, your lordship, this is a booking amount I have made, and the total amount of 55 lakhs I have paid it at page.
IOCL is here, item 1, 2.
Yes.
IOCL. No, but the first one is IOCL. They were standing outside here.
They do not have Bongaigaon refinery. Bongaigaon refinery. My lord, only 2 aspects of the matter your lordship kindly note. My lord, page, after the booking, they informed us. Page
All the
58,
IOCL houses, whoever it is.
ISL, Bongaigaon.
Have you given a copy of the writ petition to them?
No, we. Oh. Sending us is not there, we have asked for.
No, I don't know, you just call this paper.
Hello.
Dunya.
My lord, page 47, your lordship, we can 58. They say, my lord, it cannot be delivered in 2 months, but it will take 3 months. Page 58. This is the authorized dealer. It says, my lord, would like to inform you that the minimum delivery time of this model.
Let me see the NIT.
Yes, NIT is this one. That is the page 28. Then the- We have also approached. So this is the NIT, my lord. I think your lordship will be clear once your lordship gets this page 65. We have deposited the full amount also to be 55 lakh rupees. 65. This is the special conditions of the contract.
Yes.
Yes, 66. 14.1. Page 66. May I just read this? Your lordship, I think your lordship is clear. If the contractor is not able to place the ambulance according to the specification, immediately within the specified time period of 2 months, as per terms and conditions of the contract, the agency may make the alternative arrangement of providing ambulances of model not older than 2020 for a period of maximum up to 2 months. This we are doing. This we are doing it. During this period, the payment on the rent of ambulances to be paid to the agency shall be reduced by 5%, 10%, 15%. Now, second, this is the clause. So within 2 months, if you cannot pay, you will have to shoot the model of 2020 for a period of 2 months. Now, second part, in case the agency fails to provide the ambulances within the specific time period of 2 months, the contract may be terminated at the sole discretion of the IOCL. Maybe. However, the ambulance service may be continued till lining up of the new agency with a higher rate such as 10%, 15%, and 20% against model number so and so. In this regard, decision of IOCL would be final, and accordingly, they have given us this notice. Interim notice is page 72. Our deadline is, as per the contract, is 18th of this month. We need only another 10 days time because the manufacturer has said that it will take 3 months time for supply of the vehicles cost. So they are going to make it. It is intended, it is reaching on 25th. So this is the letter they have given, page 72. With reference to the contextual clause number 22, work order is 22 for hiring and operation of ambulance service at Bongaigaon Refinery Hospital. You are to deploy 2 new advanced life support. So this is a customized vehicle within specific time period of 2 months from the date of issue of the work order. It may be mentioned that notice of award was issued to you by letter number 12. So it is not 1/1, it is 17. 17/1/2020. As per the GEM form. As per the contextual terms and conditions of the contract, you are to deploy 2 new ambulance by 2nd of March 2024, which you have failed to comply. Thereby, you may have violated the contextual terms and conditions of the contract. For non-compliance of this clause, appropriate action shall be clear as ending date. Now, we have given a representation saying the vehicle is reaching on this 25th. We need only 5-6 days time. We are apprehending only if this is given, my lord. They cancel it, my lord. The amount which has been given to the manufacturer.
But then what is wrong? They're going as per the contract agreement.
No, they have not given the site also. That.
Huh?
They have
What
not
site?
given. They should take into consideration the manufacturer's letter. Also. Manufacturer's letter, your lordship will continue page 58.
No, but then the contract doesn't say that.
No. It contract may. It says may, my lord. We have already informed them verbally that it is not possible because the manufacturer is going to take more time. They have given us 2 months time. And manufacturer says it for the purpose of manufacturing this customized vehicle, it will take minimum 3 months time. So therefore the delay in the process. But anyway, my lord, it is reaching on 25th. I pray, my lord, your lordship will direct them to consider my representation.
Yeah?
Representation. 17/3/24, I have given a representation. In the meantime, my lord, subject to my lord providing my vehicle within a period of by 25th or 26th of this month. But in the direction to complete it. Otherwise, he is a MSME unit, my lord, and already 55 lakh loan has been taken from the bank, and they have provided the money to the manufacturer. That your lordship will get it at pay.
So we'll dispose it off with the representation. So you'll buy time that way.
Not by them, no, subject to that, my lord, The vehicle is reaching on 25th, 1 or 2 days delay.
No, so you're buying time from here, from now, from today till 25th,
20.
by way
For
of this order.
registration, another 2 days time.
Huh?
For registration, but another factory is there, my lord. They have not given the site as yet. That's
Huh?
why the contract. So I say, my lord, taking into consideration this. But verbally they were saying that, all right, whenever it comes, we'll give it, but suddenly they have given. The
Letter, that letter has been,
thinking letter. It is as per terms, I agree, my lord, but they have not given the site and there is a wrong letter, wrong date written.
page
One-
73.
73 is my reference. I have stated specifically, paragraph 12. I pray to allow me to deliver the new ambulance on 25/3/24, subject to completion of registration of the vehicle by the transport department as both the vehicles are on site. Page 70.
Okay, just keep this entire synopsis, I think. We'll Third, Mr. Dick, Siddharth. Then a senior counsel for the petitioner, who is sit by Mr. H.K. Sarkar. Okay. The petitioner's case is that, you can take this synopsis. I think. Till the, till what is it? The petitioner's counsel, on, this is the prayer of the petitioner. This petition is disposed of at the motion stage itself, with a directive to the respondent number.
We could keep the respondent authorities, all the respondents.
No, who will take a decision? We can't have all four of them reading the same letter.
Respondent number 2.
That is point number 2. To take a decision on the petitioner's representation date 17/3/2020. The representation, no, the copy of this order and the representation dated 17/3/2024 should be submitted by the petitioner within a period of 1 day, within a period of 2 days, a period of 2 days from today. Okay, should be submitted on or before 25 he said. So that is point number. Huh? That is petition accordingly disposed of.
We can serve it tomorrow.
On or before 25th. And tomorrow, better tomorrow, within a period of 2 days. No, certificate copy, we're not saying certificate copy, we just say copy. Yes. Then we can upload it or.
Then consider the representative.
Actually, whatever I said. Now, it should be submitted to the respondent number 2. By on or before 23 or 23/3/2024. That means tomorrow.
No coercive action.
No,
What is to have
no coercive action to be taken this. A decision is taken on the petitioner's representation. Job done for you.
Oh, done.
Huh?
Job done for the petition. I think related to the